Okay, guys, before we get started with the bill hearings, let me just a couple of housekeeping things for the benefit of the committee, and hopefully everybody else will show up here in a minute. First of all, I think I told everybody at the beginning of session, my experience with all the other committees, House and Senate, is they had what I considered regular podiums. And that I perceived that this committee was stuck with like a kindergarten version, like for like little kids podium. So we are rolling out officially what I consider taking us from AAA ball to the major leagues in terms of a real actual podium that if you choose to, you can actually present from. For those of you who haven't been in here before, there was like, again, a little kids table there for the first half of the session. So we've upgraded on that front. And obviously things are starting to get busier, which is why, as you know, we're going to start rolling out some bill hearings starting this Friday. Another thing, because we have a lot of bills we need to work through beyond the Friday hearings, we're going to move to more of a Tuesday, Thursday voting session so we can just get some more and more bills out on the floor. So when you hold a bill on Tuesday, you're going to have till Thursday to figure it out. It's not going to be this whole week we've been operating up until now. And then the other, I guess, significant change is most of the committees actually only have allowed their witnesses 2 minutes, but we've had the luxury in this committee, we've offered everybody 2.5 minutes. But starting today, for those of you here to testify, we're going to be in alignment with all the other Senate committees. We're going to move from 2.5 minutes down to 2 minutes because we just have to do that given the quantity of bills. The only other thing I wanted to point out is for tomorrow, which is going to be a very busy day here in the committee. On the schedule, it looks like we're having a briefing at 1 and then bill hearings starting at 2. Governor Moore will be in here on one of his bills, and to accommodate his schedule, we're going to let him go first at 1, and then we're going to work around that depending on how long that hearing takes. And so if you were planning to be in attendance for the governor's bill, gap period 1 year bill, don't show up at 2 o'clock. You'll be here at 1 o'clock. Otherwise, you're going to miss that bill hearing. Okay, that said, I'm going to turn it over to the vice chair because I get to break in the new podium here with the first bill of the day. So,
all right. Welcome all to what I call E-Quad, Education, Energy, Environment, and Elections. And first bill up is with the chairman, Senator Feldman. That is going to be Senate Bill 143, which is electricity, net energy metering, accrual of net excess generation, net metering flexibility act is also what it's called. I want to remind you when you're testifying, remember that we have people watching from home, as well as legislators who are not experts in your area, possibly. So please try to avoid acronyms and insider speak. We want to all understand your testimony, which we know is going to be informative. So with that, Mr. Chairman, you're up.
Yes, can I bring up I have one panelist,
Yes.
David Lapp from the Office of
David
People's
Lapp.
Counsel, our
Yes.
People's Counsel. And David, if you could come up and let me just start by saying we didn't actually have time or the benefit of having a briefing from the Office of People's Counsel. But last week, but David here did do a briefing in the House Economic Matters Committee. And so last week, last Wednesday, Lemuria did send out a link to that particular briefing. It's important because a lot of you again, may not even know what the role of the Office of People's Counsel is. And, before I describe Senate Bill 143, I do want to just say the core mission of the Office of People's Counsel is to protect and represent the interests of our Maryland residential ratepayers, whether it be consumers of electric, natural gas, other topics on matters in front of the Public Service Commission, federal regulatory agencies, and the courts. And again, you could I'd just reference you back to that link to the House briefing. And so that's who the gentleman to my left is, our Office of People's Counsel to protect our residential ratepayers. So Senate Bill 143, entitled the Net Metering Flexibility Act, relates to a very narrow issue, an issue dealing with net metering, which many of you may not be familiar with, but let me give you the Cliff Notes, if you will. That involves a billing arrangement with electric companies for customers who generate their own electricity. In most cases, it's solar panels, candidly, but the folks who are generating their own electricity, if the customer produces an excess of energy over what that customer uses, the excess amount gets fed back into the grid, and the customer gets a credit that can be applied to their bill the following month. That's basically what we're talking about. Now, notwithstanding that Mr. Lapp is here, we're not only just talking about residential ratepayers, but this arrangement also applies to businesses, commercial businesses. In fact, I'd reference the committee to page 2 of the fiscal note, which is, and you'll see small business effect. If you have it in front of you, I really want to point to that. It says for the 12-month period ending April 30th of 2022, commercial net meter customers were paid $3 million for excess generation, and goes on to talk about how this bill may be particularly beneficial to small businesses as they attempt to sort of gauge their excess generation. Net metering can work for them, so it's not just about residential ratepayers is the important point here. But net metering as a policy goal is, I think, an important tool we have in the toolbox here in Maryland and other states to encourage investment in renewable energy, particularly solar, economic growth, because solar panel installations tend to be pretty labor intensive. It reduces our interconnection distribution costs, increases resiliency of our grid, and a lot of other really good things. Now, what Senate Bill 143 specifically deals with is an issue that Delegate Corman and I, or the majority leader, during the campaign, we're talking to constituents, and under current law, the net metering law arrangement in Maryland, unlike several other states, is not very flexible. It's very rigid. It involves 1-year billing periods that basically run to the end of April of each and every year. And what happens is the excess goes month to month towards the next month's bill, as I described earlier, that excess energy. But the consumers at the end of the bill period are, and this tends to be April of each year, are required under the current arrangement in Maryland to take a cash payout in April, meaning that they lose the credits that they've accumulated up to that point. They are mandated, basically, the only option on the table at the end of the 12-month period is to get a check of some sort, and typically a pretty small check. They're not given the flexibility or the option to have those credits accrue or roll over into the summer months, for example, when usage goes up and the bills go up. It's this April 30th cutoff. That's the current arrangement here in Maryland. And so for various reasons, we do have a state cap on how much net metering we're going to allow in the state. And right now, the Public Service Commission did a report November of 2022. We're only at about 34.4% of that cap, which is 3,000 megawatts for net metering. So there's a lot of space still. Again, we're only at 34% of the cap to incentivize more folks to utilize net metering, which is, again, good for all the policy reasons I described earlier. Now, one way to incentivize consumers, whether it's residential or the small businesses that I referenced in the fiscal note, is by offering options that provide more flexibility, not stuck, limited to this very rigid 12-month accrual period, which ends in April and requires this cash out. No ability to carry forward that excess to future months. So what Senate Bill 143 does as introduced, and I do have some amendments because I have taken a look at a lot of the testimony that's been submitted in writing, and which I think has caused me to think about some aspects of the bill. As introduced, it would change the billing cycle month from when the accrual of the net excess generation cash out payout date from April to August. Now, the thinking there as drafted was to give consumers the ability to utilize to offset the expense of the additional consumption in the summer. That would be one option under the bill as drafted. But in looking at the testimony that was submitted, some of the pushback, the moving from April to August probably does not appear, the juice may not be worth the squeeze, and it's not clear to me that that necessarily will yield the benefit and the flexibility that I think the intent of the goal here is to just give more flexibility to customers, to consumers. But the second part of the bill, I think, is more significant. It would allow customers to roll over, carry forward their credits indefinitely, instead of only having the option of taking the annual cash out after the 12-month period. This is a practice done in several other states. Massachusetts, Oregon, and even the District of Columbia lets residential customers as well as businesses do that, particularly, as I mentioned earlier, beneficial to small businesses as the fiscal note writer, an environment of rising energy costs. The option of carrying forward excess generation indefinitely and applied against future energy uses could be very, very meaningful. And so that's essentially what the bill does. The bill as drafted provides two options. It takes the April cutoff period to August, take advantage of this as summer usage, or this rollover indefinite period. I'm suggesting that maybe we just stick with the rollover carry forward indefinitely based on the testimony, but I'm open to maybe some suggestions to keep that in, but that's just my read on the testimony. There's a lot of testimony. Most of it's favorable or favorable with amendments. You've got a lot across the political spectrum. You've got the Maryland Farm Bureau straight up favorable on the bill as introduced. You've got Maryland Energy Administration and some of the utilities raising concerns about the IT costs of making this change in their billing system. And SMECO, I think it was a similar thing. There are small folks, and they, I think, indicate that for a small player like them, maybe the administrative costs or the IT costs would be difficult. But that's sort of the nature. I don't think anybody really is pushing back on the idea of, which is the main goal here, of providing our residential and commercial net metering consumers, again, including small business, more flexibility rather than this current rigid system we currently have in Maryland. There is some testimony from the Public Service Commission. The Office of People's Counsel, the protector of residential ratepayers, is here in support of the bill, and I'll actually let him go next. But as far as some amendments, let me just throw in a couple that I do think make sense, no matter how we deal with the bill. One amendment will include community solar programs, making them eligible for indefinite rollover credits. I think the reason that's important is one of the criticisms of solar rooftops is it requires a fair amount of money. And so you're not benefiting. Community solar, on the other hand, was designed in part to free up for folks low, moderate income, because you're buying into the community, and more from a environmental justice standpoint. Otherwise, that was the premise of community solar. So this amendment would extend this indefinite rollover to community solar customers as well, not just limited primarily to the folks who have solar panels on their roof. There's a technical amendment that clarifies that a net metering customer generator can opt into the rollover, even if they had chosen a cash payout in the prior years. And again, I'll just finish by saying that I do look forward to working with the utilities and the others to tighten up some of the language about the mechanics of how this would work. But the end goal here is more flexibility, good for customers, good for small businesses, and that's really all the bill does. So it's narrow, specific, and in a nutshell. So, Madam Chair, I'd like to maybe pass it on to our expert a little bit more than myself, our Office of People's Counsel.
I was going to suggest that, Mr. Chair. Why don't we hear from David Lapp, and then we can have questions for both the sponsor of the bill and the People's Counsel, and then we'll take other advocates on both sides of the bill. Thank you. Mr. Lapp, welcome. You're not just a face on Zoom.
Yes.
Nice to have you here.
Thank you, Vice Chair and Chair and members of the committee. David Lapp here for the Office of People's Counsel. Appreciate the opportunity to speak here today. We're pleased to be here in support of SB 143 because of the added flexibility it gives to net metering customers in Maryland. I'll be brief and make 3 points. One is that distributed energy resources are really important for customers as the state transitions to meet its greenhouse gas reduction goals. Rooftop and community solar are important distributed energy resources. And they are technologies that are good for consumers and the environment. They potentially lessen the need for costly distribution system enhancements. They increase the distribution system's resilience, its ability to handle adverse weather events, and they lower emissions. The second point is that this option of accruing credits sends important price signals to customers that are considering rooftop solar or subscribing to community solar and who are thinking about electrifying in the future. The electrification may be household heating and cooling appliances, space and water heating and electric stoves, or it could be electric vehicles. They can acquire more solar now than they need today with anticipating that their electric usage will increase in the future, and they can take advantage of those credits that they accrue. The third point is that while this added flexibility will be great for customers, the effect on overall rates should be negligible or beneficial. As Chair Feldman noted, we understand there's going to be some amendments to fix some of the issues that are really relatively minor, but we think should be fixed. And
Sorry, you're the first victim of the mean chairman's new time limit.
I'm done. We asked for a favorable report. Thank you.
Okay, if someone wants to ask Mr. Lapp a question that may allow him to add a little more, that would be fine. Mr. Chair, you want to come back up and let's see if colleagues have questions. If not, I have a leadoff one. I don't see any lights. Mr. Chairman, you did mention that that there is a lot of favorable testimony in our folders. There is one unfavorable, and I just want to give you the opportunity to address, and I'm just going to read you one sentence, which is, this is from Potomac Edison First Energy, who is requesting an unfavorable report for the following reasons. And they say, allowing customer generators to accrue net excess generation indefinitely could lead to the further subsidization of net energy metered customers by all the other customers in our distribution system. So if you could speak to that, that will help us, I think, as we go through this.
I did see that. Obviously, none of the other folks, the utility industry raised that issue. The one thing that we have a cap, okay, let's just, there's a reason we have a cap. It's a little similar to electric vehicles in the sense that when you use net metering, you're not necessarily paying into the distribution system that is being borne by other players. So for that reason, we put a very specific cap. We don't want everybody in the state to use net metering. Although, again, for all the policy reasons I mentioned, it's a really, really, really good tool for investment, to incentivize renewable energy. It sends pricing signals, all that good stuff. And so we've tried to strike a balance here with a cap. We're only at 34% of the cap. I think if we get closer to that cap, that argument would be more compelling. But at 34% of the cap, I don't think that's compelling, which is why they're the only one that raised that issue. Certainly, Mr. Lapp can weigh in. So it's an issue of other folks are paying in to incentivize and promote a good policy goal that is working around the country. But if we ever get too many people playing in, then we're going to have to figure out a sort of like with EVs, how do we collect gas tax? I mean, we're not going to stop doing EVs because EVs don't pay the gas tax. So those are some of the things that I think are built into that point.
Translate, EVs are
Electric vehicles, right? They're not paying a gas tax. So in theory, they're not paying the fisc, but we have bills in this committee that are incentivizing the purchase of them. So I think that's kind of a similar sort of analogy from where I sit.
Add to that briefly.
We agree with that assessment that the cap does provide a protection. We do think as we get closer to the cap, this issue is one that should be addressed. But right now we're trying to incentivize what ultimately will be in the long-term interests of customers.
Senator Gallion has a question.
Thank you, Madam Vice Chair. Thank you, Mr. Chair, for this bill. As we've heard the discussion, we've heard it pretty much just talked about solar energy. Where do other technologies such as like anaerobic digestion fit into this bill?
Maybe you could answer that on the net. I think the most of the net metering customers are solar panel. Again, this bill then does expand it to community solar. David, if you've got some thoughts on that.
Theoretically, it's possible that other technologies could take advantage of it. It depends on it. There's a eligible customer generator is the term in the statute, and that is not confined to rooftop solar, but primarily it has been rooftop and community solar.
Yeah.
Good. Senator Gallion. Okay. Senator Brooks.
Thanks, Chair, and Chair. Yeah, as a net metering customer, I do have panels. And they were telling us that the current value of $1 is better today than it is tomorrow. Now this, if I'm reading this correctly, this feature has an opt-in, so one could opt in to.
Yeah, I
the
think
extended-
the bill is, you could still do the current model, the current law allows you on April 30th to basically get a cash out check. In other words, it goes month to month, you can carry over month, but when you get to April 30th under current law, that's it. You can't carry the excess into May. You need to get a check. You can do that option, or you can explore this other option of carrying it forward past April. That will be your choice. And that, right now that's not available. Right now, the only option on the table is on April 30th, you get a check for the excess. There are no other options.
So on this bill, I could opt in 1 year and then opt out the next year?
Yeah, well, that's part of the discussion. I think we want to tighten it up
Oh,
because I think one of the testimony was sort of, don't want people gaming the system or some of that language. And I think that lends itself to some technical tightening up so that to avoid any problems, if that's the gist of your question, I'm not sure. But candidly, yes, I think, well, that's going to require a little further conversation, some of the mechanics about if you're using the cash out 1 year and you go to the carryover, can you go back and forth? I want to make sure we get that part of it right, which is why I don't think we're quite ready to roll this out to a voting list yet.
all right, thank you.
Yeah. Yeah.
Okay, I do see a light. Senator Rosa.
Thank you, Madam Chair, and thank you, Mr. Chair, for the continual education. I have heard from one of the 5 municipally owned utilities, and they were expressing that they provide electricity for less than 1% of the population, and they're concerned about adding a separate accounting system, and it looks like they are looking to opt out of the bill. So I didn't know if you had been able to meet with some of them and address their concerns.
Yeah, I haven't talked to Tom Dennison at SMECO. I would say that, the arguments in the past on on some of the energy bills about the little folks are in a little bit of a different position to put the IT investment in place to have major overhauls of their billing system has resonated. And we've had a number of exemptions for the co-ops and SMECO, and that might be something to consider here. I'm open to that kind of conversation because I think the gist of their opposition is IT investment, that they're not a big major utility. And we've carved out some exemptions for those folks on that basis previously, and this may be one of those as well. But I do look forward to working or talking to them some more about that argument.
Okay, I see no other questions from colleagues for the two of you, so let's go on to other witnesses who are favorable to this bill. Katie Nash with Sunrun, John Fiastro, Brett Liniger, sorry. And let's have one more, Brett Spruill, and then Lisa Smith. Lisa, are you here from the PSC? There we are. Let's see if we can why don't we see if we can get all 5 of you up there? Welcome. You all can go in the order that I mentioned if you like, or if there's some other reason for a different order, that's fine too. Make sure you introduce yourself, say your name and your who you're representing. And remember, you only have 2 minutes now.
Yes,
So if you've
ma'am.
been practicing for 2.5, you get 2.
I got it.
Okay,
Thank you, Madam
Katie
Vice Chair. Members of EQuad, deference to you, Madam Vice Chair. Katie Nash, Fiastro Consulting on behalf of Sunrun in support of SB 143. Sunrun is a leading provider of storage and solar services in the U.S. with nearly 800,000 customers nationally, including tens of thousands here throughout Maryland. Thank you, Mr. Chairman, for bringing the bill. I will condense my testimony. SB 141 moves us in the direction of national best practices, giving customers more options to maximize economic benefit of their solar facilities. And I've highlighted some of the good reasons on why we should move now in our written testimony. I'd like to highlight one point, though, regarding the indefinite rollover provisions of SB 143. We know that customers will be looking to size a solar facility in anticipation of increased future electric usage. And as we move forward towards electrification, SB 143's provisions enable the customer to be able to utilize the full value of any credits in future years when usage increases. And we know that's coming. I'll just add respectfully that as utilities make investments to modernize the aging electric infrastructure, ratepayers will be seeing and are seeing 10 to 15% in rate hikes. BG&E just announced last Friday that they're going to seek 15% rate increase over the next 3 years to that effect. This legislation also accounts for anticipated hotter summer months, depending on which way we go, Mr. Chairman. And I know that as we look at greater consumption on our grid, this is an opportunity, and we have an ongoing opportunity to look for ways that we can lessen the burden on our electric infrastructure and free up resources to avoid unnecessary costs. Sunrun appreciates the opportunity to be here and urges a favorable report of SB 143.
Okay, thank you, Ms. Nash. Why don't you turn it to Mr. Fiastra?
Thank you, Mr. Chairman, members of the committee. For the record, John Fiastro on behalf of Arcadia. Arcadia is a subscriber coordinator in the community solar space. They are a nationwide company with 150,000 customers. And in Maryland, they have about 15,000 customers. In Maryland, they manage about 54 community solar projects, totaling 84 megawatts. Nationwide, they have about a gigawatt. That's 1,000 megawatts of generation under management. To give members of the committee some perspective, 1,000 megawatts is about the equivalent of one of the reactors down at Calvert Cliff. So they are a significant player in the state space, and they are the country's largest subscriber coordinator. Arcadia asked this committee to vote this bill favorable with the amendment offered by CCSA to include community solar within the contemplation of the legislation. Arcadia prides itself on guaranteeing customer savings, and community solar customers with Arcadia save anywhere 5, 10, 15% depending on the product. In fact, they will list the savings on the customer dashboard. And this is important because the current net metering construct can lead to a confusing customer experience. You see, when we roll credits at the end of the year, a customer has thought that up to that point, they've been achieving monthly savings. And then they get a check for maybe $4 or $5. And they say, well, geez, whiz, is this the totality of my savings? Is this what I signed up for? When in fact, they might have been saving $5, $10, $15 on a monthly basis. But that's not what they see. And it makes it very difficult to explain to them at the end of the year. So it gives the false impression that the true up check is the totality of the savings, as I had mentioned, and that's just not true. So this bill intends to clear that up for traditional net metered customers. We ask that the amendment is adopted to include community solar customers. Thank you. That concludes my testimony, Mr. Chairman.
Mr. Leininger.
Thank you, Mr. Chairman and members of the committee. Brett Leininger on behalf of the municipally owned utilities, testifying in support with an amendment. Also, thanks to the chairman for speaking with us a few weeks ago. As was mentioned before, we're very small. Just to give an idea, we have Easton, Hagerstown, Williamsport, Berlin, and Thurmont. Easton has just under 11,000 customers in total, about 58 to 60, somewhere around there, do net metering, so it would be an even smaller portion. Berlin, the town of Berlin is about 3,500 in total. Thurmont, 2,900, and about 1,000 for Williamsport. So talking about very, very small population. Additionally, the municipals also provide, they're the utility for other services such as internet, cable, water, sewer services, and they're under the same billing system with regard to that. So if there is at the end of the 12-month cycle some kind of balance, it's often opted by the customer to apply it to that other bill. So with that, we ask for an exemption for the double billing. We're complete support of net metering, but the having this option for the indefinite period of time is a lot for a very small portion, a very small population.
Okay, Ms. Smith.
Good afternoon, Chair Feldman, committee members, Lisa Smith, Director of Legislative Affairs for the Maryland Public Service Commission. I will mostly defer to my colleague Brett Sproul, who will provide some informational, technical testimony, but I just wanted to convey that we will be ready to implement and happy to discuss. As Chair Feldman mentioned, there are some little technical, it sounds like some amendments on the table and things to work out, and we're happy to work with sponsor and the members to work through that. And Brett will kind of provide a little more information. Thank you.
Great. Good afternoon, Mr. Chairman and committee members. My name is Brett Sproul, and I'm a technical advisor for the Maryland Public Service Commission. I'm here today to provide brief commentary and answer any questions related to Senate Bill 143, also known as the Net Metering Flexibility Act. This bill has two main changes to address: changing the billing or cash out date from April to August and allowing a customer to accrue net excess generation indefinitely into the future. As Chair Feldman mentioned, the consideration to address and amend the date change from April to August, the PSC staff is happy to work on finding a date that is most optimal, and that is one of the concerns that we had regarding this bill. The current scenario minimizes a customer's cash out in April and thereby maximizes the overall value of the customer's net metering benefit. If the billing or cash out date changes to August, a customer could receive a higher payout, but ultimately less benefit. And this change has the potential to benefit some customers at the expense of others. Second, allowing customers to accrue net excess generation indefinitely could potentially increase the overall compensation that goes to net metering customers. A net metering customer is only required to pay a small customer charge for their utility bill and not other portions of their bill when they have net excess generation for a given month. Indefinite accrual of net excess generation could increase non-net metering customers' bills because utility rates need to collect the full cost of the system regardless of usage. I will also note, as mentioned in PEPCO's informational filing, if any utility IT or billing system changes require changes, they will be borne by all ratepayers within Maryland. There are a few other minor concerns, but we are happy to work with the sponsor and other staff to address these concerns moving forward. Thank you for the time to speak.
Good, thank you. Thank you for your testimony. Any questions for the panel? We've got Senator Washington.
Thank you all very much, and thank you for this bill. I had a few questions, but I actually want to ask the PSC the last. You said that the full cost of the system has to be paid regardless of usage. And so for myself and other members who are new to this subject area, could you explain that?
So for that instance, the per se, if the utilities have any system changes or IT changes that they have to make, those costs that they take to implement those changes typically are borne by all ratepayers. Fraction of that is spread out to all ratepayers, say within PEPCO or BGE service territory. And that's what was indicated partially in that phrase.
I guess if you could explain maybe the regulation or the deal in general. So are the utilities guaranteed a certain amount of revenue or costs? You're saying regardless of how much one uses, you said the full cost of the system has to be recovered. Can you explain that?
Yes.
And again, this isn't a rhetorical question. This is a genuine, so we can understand how this works.
I would say another way to phrase that is, it might get a bit technical to go into for net generation and net. Yeah, no, absolutely. I'd be happy to help. For net generation and net metering customers, so if they have net generation and excess net generation for years to come, say in 3 years, they have this built up bank of generation and may not be paying a utility bill. They'll only be paying a small customer charge of that bill, which is a flat rate for utilities, whereas their usage still has to be accounted for from the utility. BGE and Pepco still have to account for the 1,000 kilowatt hours that they use per month. And that the cost of supplying that, the distribution and supply cost, will be borne by all ratepayers, even though that individual customer is covering their usage with their excess generation that they've banked up over time.
Okay, yeah, I'm sorry.
Yeah, so we're still, maybe we could back up and just talk about just a regular rate payer. So there's I guess a certain amount it costs the utility to generate and distribute the energy. Is that, are those the three costs, or are there other costs? What are the costs?
And typically on a bill, you'll have a distribution and a supply portion are the two major.
Is there another cost not accounted for in the bill?
There's also transmission costs as
Transmission
well.
costs, okay. So now we understand that. So for someone who's not using a solar panel, they're being charged $100. Okay. Now for the person who is using net metering, are you saying that it costs a certain amount to provide that same amount of energy? Does it cost the company the same amount to provide to someone who is not using energy from your generation, but that is producing their own energy? Does it cost you the same?
In terms of for the utility? Yes. So the cost would be the same, once again, regardless of usage. So the customer with net metering, because their net generation that's going back into the system would cover their $100 bill. And the customer that doesn't have net metering, they don't have anything, so they would have to be paying that $100 bill. And what I'm saying with that sentence is the net metering customer, that $100 is still a cost that will be borne by the utility. However, they are not paying it due to their banked up generation that they're supplying.
Would I be generating energy that is sold or used by the utility to someone else? In other words, if I generate more than what I use, what happens to that excess?
That excess generation will be applied to your current monthly bill, and then.
But it generates more than the current monthly bill.
That's,
John, feel free to go ahead.
yeah, I mean, I think that's the bill before us, Senator, right? So we established, 20 years ago, we said there is a net metering program in the state. And the whole concept was based on the idea that if you put these panels on your roof, your meter will spin backwards.
Mhm.
So you go from 1,000 kilowatt hours consumed. If you've had 1,000 kilowatt hours produced, you should net out at zero. So so we said this. The statute says that you can build as a customer generator 200% of your annual consumption. You're eligible for that credit of 200%. So if you produce if you consume $1,000 worth and you produce $2,000 worth, then the utility should be paying you a check for $1,000.
Mhm.
All right, that's not really, I mean, that's settled by the assembly. It's a
Right.
policy established under the public utility article. Now, as we talk about this bill, current statute says there's only one way to true up, and you get a check at the end of April. Boom, you get your $1,000 check. The bill, as my client understands, I understand it, is that credit can roll indefinitely. If you'd like it to, you can opt into that. If you are an installer, in all likelihood, you've looked at your customers' past usage, and you've tried to right size that program. So if you're looking at someone's roof and you say, well, you've used $1,000 worth, we're going to build panels on your roof that are going to generate the equivalency of about $1,000 on an annual basis. Now they're going to look at that from type of generation, kilowatt size and capacity, but I'm just trying to break it down to numbers to make it more consistent with what we're talking about in the bill. So if you've right-sized your program, your net metering benefit at the end of the true up should be nominal, minimal, right? But if you are outsized, if you have built, and believe me, there's easier ways to put money in your pocket than to overbuild your solar array for your house. But in the event you were to, consistent with the allowances under statute, you could do that and you would get a check. The bill only says that you could roll that instead of getting a check, forego that and just have it roll indefinitely.
This is another bill, another time, and maybe we should, perhaps the PSC, we can better understand how all of this works. But it seems to me at some point, what is being produced is more valuable than at any time. If is the energy being produced, is there any gap between what you get as a check versus what is produced? In other words, is any portion of what I would produce able to be used by the utility to be sold or used for other ratepayers?
And
Doesn't it go into the overall system, right? We're producing it, it goes into the overall system, it goes into your system, and then it's redistributed. It doesn't have like a Senator Washington, sort of ion on it, and can only be used in my, I don't even know if that's the right word, but being used at my house, it could be used anywhere, correct?
yes, that is
Right,
correct.
Right. Okay. All right, I think that's probably enough here. So I still don't fully understand the statement that somehow it hurts other ratepayers if some ratepayers can pay as they go and actually possibly can put more into the overall system, contribute to the system overall, why that hurts ratepayers, except for your sentence about essentially being, I guess, held harmless, or there's a full cost of the system regardless of usage. So if there's a full cost of the system regardless of usage, there's no incentive to conserve or to develop mechanisms to reduce consumption. Would that be what I should get from that statement?
And I think to further clarify the statement,
Yeah.
I guess another way of phrasing it. So for a net metering customer, if say you don't have to pay a bill, you won't be, if your net generation covers all of your usage for a given month, you won't be paying a distribution or a supply portion on the bill. However, there are still distribution costs with the utility assets, the wires going into your house that have to be accounted for. However, as the net metering customer, you're not paying that portion of the bill. So the utility will spread it. Yes.
Good. So it's not an either or. So potentially of the $100, maybe you're saying, so rather than kiboshing the whole thing, you're saying that maybe some portion of delivering it, you have a cost to deliver the energy regardless of where it's produced. Is that what you're saying? Oh, okay. And you can quantify that dollar amount. Is that correct?
The distribution.
Would the utility be able to quantify that?
I would have to check with the utility, but I believe
And
it
so
should be.
conceivably that could be accommodated.
Potentially,
Okay.
yeah, I would need more
Yeah,
information.
no,
on it
I
as
hear it.
well.
Okay, thank you. Thank you very much, Mr. Chair.
Sure, and I think I tried to address that a little bit in my comments about the distribution. Because they're not paying into, just like an electric vehicle, person's not paying a gas tax, but as a trade-off, there are all these other policy goals but that's why we've had a cap, because we don't want everybody doing that, because that would be a problem. So that's why we have a cap in place, but I don't want to make any commentary here. Any other questions for the panel? Okay, seeing none, that concludes the bill hearing on Senate Bill 143. We're going to next move to Senator Brooks. on Senate Bill 489. And Senator, I've got signed up as your sponsor panelist, Mark Posner. Mr. Posner here from the Sierra Club.
Oh, yes, could you come on up? Yeah.
Okay, why don't you come up here and why don't you have a seat? And
We've got
Senator Brooks, why don't you explain Senate Bill 489 at
uh,
the new podium?
at the new podium. Thank you, Chair. I'm looking forward to this. Okay. All righty, Chair Feldman. Vice Chair is not here. Members of my committee. For the record, I'm Senator Ben Brooks. I represent the 10th Legislative District in Baltimore County. Thank you for the opportunity to testify before you on behalf of SB 489 as Public Service Commission, Certificates of Public Convenience and Necessity, local permits. This bill merely fixes a gap in the current statute, which arose from after the Supreme Court.
Actually, I apologize. I think I misstated. Okay, we've got, I think I had the wrong, I apologize, Senator Brooks. We're on Senate Bill 489, correct? Is that what you?
That is correct, Senate Bill.
Okay, so I
489.
apologize. I had your sponsor panelists are Cyrus, Tasha Corey, David Gelmans, and David
David
Lapp,
Lapp,
Office of
yes.
People's Counsel. I
Yes.
think I misstated that. So
Right,
back to
and
you, Senator.
And we have one virtual also, Chair.
Correct.
Yeah. Yeah. Yeah, this bill merely fixes a gap in the current statute, which arose from after a Supreme Court of Maryland decision in the Board of County Commissioners versus Perennial Solar LLC in 2019. As amended, SB 489 states, notwithstanding any inconsistencies with a local law, regulations, or plan, a county or municipality corporation is authorized to and shall process within a reasonable time any local permits required under a Certificate of Public Convenience and Necessity, better known as a CPCN. The Public Service Commission has sole siting authority over solar projects over 2 megawatts. Yeah. To approve sightings of such a project, the commission issues a CPCN through a formal written order. The CPCN process includes requirements for CPCN applicants to provide information and seek input from the county's municipal corporations and the public at least 90 days prior to submitting their CPCN application, and provides opportunities for counties and municipal corporations to provide substantive input on the project for the PSC consideration, including as parties to the CPCN proceedings. CPCNs includes conditions that requires projects to apply to the county and other municipalities, municipal corporations where the project is located for ministerial and technical permits as site plans, stormwater management and plan approval and building permits, etc., prior to the start of the construction. Some counties have taken the position that they do not have the legal authority to issue such ministerial and technical permits based solely on the issuance of a CPCN in the absence of the preemptive local zoning approval. This position will prevent solar projects from moving forward because the permits necessary to begin construction. This may lead to years of litigation that will prevent otherwise shovel-ready projects from moving forward. SB 489 will provide counties and municipal corporations with legal authority and require issuance of all permits and approvals required by the CPCN, fixing this perceived gap. The proposed legislation would not impact any aspect of the CPCN process, local permittings and other changes, preemption of local zoning approvals, but clarifies that the local government have the authority to process ministerial and technical permits required prior to the start of construction. If enacted, the state would be able to achieve its renewable energy and climate change sooner by allowing projects to move forward that otherwise would have been delayed years as waiting on a court decision. So for that reason, Chair, I request a favorable report. We do have a panel, and if we were to go with Cyrus, you can go first. Yeah.
Mr. Chairman, Madam Vice Chair, members of the committee, Cyrus Tashikori on behalf of Americ Action. Thank you for the opportunity to testify. This is a very straightforward bill. As you know well, in-state utility scale solar will play a big part in meeting the state's climate goals through 2030. And thanks in part to the work that many of you have done over the last few years, as well as Public Service Commission rulemaking to address CPCN delays. Solar projects can finally go through the CPCN process in a reasonable amount of time. Today, as Senator Brooks mentioned, local governments and the public have a lot of input into that process. We as developers take our draft CPCN application, we give it to the local community first. They have at least 90 days to provide input. Then we have to show the PSC in our final application how we incorporated or addressed that input. That's just before the process even begins. There are 2 public hearings as part of the process, takes a year or more. So why do we need this bill? This bill, again, addresses projects that have gotten their CPCN approval. They may be months from construction. And as the PSC has said, some local governments are arguing that despite preemption, despite this very robust process, that they don't have the authority to process things like a driveway permit for already approved projects. So this argument would, nullify the PSC's citing authority, and this bill fixes that. You may hear that this bill creates new work or complications for local governments. We don't believe that's true. And I'm going to just leave you with 3 facts to remember if you do hear those arguments. 1, things like stormwater permits or driveway permits, those would have to occur anyway, even if we went all the way through a local process. 2, while these projects are critical to Maryland's climate goals, they're actually very few each year, maybe 5 or 6 single digits a year across the entire state. And lastly, some local governments have actually processed these permits before this kind of novel legal argument has popped up. So with that, thanks.
Okay.
Thank you, Chair. Members of the committee. My name is David Beaglemans. I'm a lawyer from the law firm Gordon Feinblatt, appearing today on behalf of Americ Action. As a lawyer, I've handled the CPCN permitting for more than 35 solar projects located across the state. SB 489 is a technical bill, but it's actually critically important. Right now, we have a situation where the Public Service Commission, after extensive year-long reviews, has approved CPCNs for solar facilities, but certain counties have indicated they don't have authority to issue required development permits needed to build those projects. This legislation fixes this regulatory gap by providing that authority. I would like to take a moment today to address some criticisms of this bill that you may hear either in oral or written testimony. First, this bill does not change the Public Service Commission's authority with respect to power plant siting. The Maryland Supreme Court has already decided this issue, and this bill does not change that. Second, this bill does not limit local authority or fast-track development. In fact, again, this bill clarifies that local governments have authority to review and issue these permits in response to concerns expressed by some that they don't currently have this authority. Third, county laws and standards are a significant part of the CPCN process, and this bill does not change that. In fact, county input is so important that for every CPCN I've worked on, there are conditions requiring compliance with all county design standards, including setbacks and screening. And fourth, local governments, frankly, are best situated to conduct these reviews because they do this all the time for every development within their borders. They have the staff and the expertise needed to do this. You have written testimony in front of you from the Office of People's Counsel. You have the People Council here, in fact, and MEA, 2 agencies deeply involved in these issues, supporting this legislation. And you have a letter from the Public Service Commission, a neutral regulator, saying this issue is real and this legislation would solve it. I can tell you based off experience, this legislation is critically important. We urge a favorable report. Thank you.
Okay, Mr. Lapp.
Good afternoon, Chair. Again, and members of the committee, thanks for the opportunity to be here. David Lapp for the Office of People's Counsel. We're pleased to support SB 489 to help prevent undue delays in the siting of new generation facilities. Those delays are detrimental to utility customers in the state because they reduce competition in the market for generation and delay the availability of renewable energy. SB 489 has the potential to put downward pressure on energy prices for two reasons. First, undue delay for any type of generation siting in Maryland decreases supply and therefore leads to higher prices for customers. Second, those adverse effects of delay are exacerbated when the delays are for the siting of renewable energy such as solar power, because the state requires through the renewable portfolio standard all suppliers to procure a percentage of renewables or pay alternative compliance penalties. More renewables thus helps customers by putting downward pressure on the price of renewable generation. New cleaner generation also furthers the state's efforts to meet its greenhouse gas reduction goals. Importantly, the bill maintains the ability of local governments to require developers to obtain permits. The bill simply requires the local government to process the permits within a reasonable time. Finally, our experience before the Public Service Commission is that the frequent delays that energy developers face from the slow pace of local permitting creates an administrative burden on all parties when developers need more time and must request extensions because they are waiting for local permits. In some, unreasonable delays caused by local siting authorities are detrimental to utility customers and the state's interest in keeping energy costs low and reduce competition in the market for generation. We ask for a favorable report. Thank you.
Okay, thank you to the whole panel and Senator Brooks. Questions? We've got Senator Augustine.
Thank you, Mr. Chair. I've got a couple. First one is, have you all been able to recently successfully get projects off the ground?
I could answer
In
that,
Maryland?
Senator. Yeah, so there have been some successful projects. Unfortunately, it's, maybe one or two a year. That's out of, as Mr. Tashikori said, maybe 5 or 6 that are permitted. So some projects in certain counties have been able to move forward, but unfortunately not the vast majority of them.
I could just add that since in 2021, some of the CPCN issues were addressed both by the General Assembly and by RM 72. The process is rational. It's starting to work. It takes a long time anyway to move through the process, but it is working a lot better than it was before the General Assembly got involved in 21. So it's moving in the right direction. And this is really looking at projects that made it all the way through, are close to construction, and now this argument's being raised.
Okay, and so the challenge that I think that I'm having right now, you all are saying that you're not limiting the locals, but every last one of them are saying that this does, like all of them are saying it. And they're saying explicitly that it's, if they are directed to process, in other words, they just got to give the permit. They don't have, how does that give them the authority to do anything if that is the way it's currently being interpreted?
Well, Senator, this legislation is partially in response to the position of some counties that actually they don't have authority to issue these permits. The way CPCNs work is it's a year-long, very extensive review. And at the end of that, there's a series of conditions that are attached to that permit. And what those require for every single project that I've worked on is for the project to go to the county and apply for standard development permits. So we're talking about things like site plan, permits, stormwater management plans, very basic things like entrance permits or building permits. Counties are really the right place to do that because they have to do that for all kinds of development. So the Public Service Commission approves the project, then there's these secondary permits the counties need to do. This legislation authorizes them to issue those permits when a CPCN's been issued. So it's
okay. So I think there must be some kind of that is not how any of them are interpreting what this bill does. And we don't have to have this conversation now, but they're not interpreting. And maybe there's room to discuss that. If that's not the intent, they're reading it not that way. They're reading it that basically any and all authority is being taken from them in these instances, not what you're suggesting right now. So I think that there might be some work that would have to occur in order to make it a little clear what your intent is versus the interpretation of all of these local jurisdictions.
I think,
If I could say, I think the county, there is a misinterpretation here. So far as the scope and the intent of the bill. And we got a ruling from the AJ's office on that. And I think that letter maybe it's in the file. But yeah, I think it's a misinterpretation on the county's part. But here again, we did get the ruling from the AG's office.
Can I just weigh in here? And we do have a letter from the AG, but before we go to the next one, I actually think from the Public Service Commission, who's here just for information purpose only, I think they may want to weigh in on yours since you've opened this question. She was signed up to testify anyway. So why don't you, Lisa, can you take a crack at Senator Augustine's, this back and forth between interpretation?
Absolutely. Thank you, Mr. Chair. And Lisa Smith, Director of Legislative Affairs, again, on behalf of the Maryland Public Service Commission. And the Public Service Commission, we were happy to work with the other folks on the panel. And I think it's a drafting issue that can probably be fixed because this came up with MACO on the other side of the street. And I think process was intended, at least from our perspective, process was intended to make a decision whether favorable or unfavorable. So maybe that's a wording issue. It wasn't, in fact, our position as the PSC is that it shouldn't be approved because exactly as was already stated, the state does not have authority over those permits. That is local authority. So we were not comfortable actually with language that would say they shall approve. Does that help?
It helps, but it seems that there needs to be some conversation then based on the interpretation and the way that the language is being interpreted. That's all that I'm suggesting. Just you're saying one thing and I get what you're saying. I understand some of the intent, but how it then is interpreted is something different. So that's helpful, very.
And the hearing is obviously very helpful because this has come up and that's a great point.
Okay, well, we want to get to now you were actually, since you're here and you were already signed up to testify for only information purposes, was there anything else about the bill you wanted to add beyond this one issue?
Chair Feldman, it was more of a Me Too testimony. We just wanted to be here to, I think most of the points were already made that we would agree with, but I just wanted to state that, yes, the commission does agree. We had a case come up after the rulemaking that was mentioned and after the last legislation and after perennial. And in that case, it became apparent to the commission that a legislative fix would be needed because the county was saying that they thought they lacked the legal authority under the current law. And so the commission believes absent legislative action, we would have very time consuming litigation. So I just wanted to kind of be here to mention
so we'll have to be the arbiter here. Okay.
If I could address Senator Augustine.
Yeah, go on.
So just two clarifying points. One is this bill addresses non-discretionary permits. These are not siting issues. These are setbacks. Have you met the technical requirements under state law for stormwater permits, things like that? And in that box, the Public Service Commission approves the siting of the project, but let's say the setback from the road is in the conditions. And what this bill says is when you go to look at the site plan review, like you would in a local permit, you can't just put that on the shelf. You actually have to process it. What David was saying was that in fact, on all the CPCNs he's worked on, the Public Service Commission has actually said, go with the local setbacks in local regs. It's still the CPCN, dictating the setback, but it so happens that in every single one of them, they've said, respect the local setbacks. Could the PSC say the local setback is 20,000 feet from the road? That's not reasonable and we'll do a different setback? Yes, but up to this point, even including the project that brought this issue up, all of the conditions in the project respected the local regs, and the argument from the locality was we don't have the authority to look at this, so that we're fixing that. I hope that helps.
Wanted to then take away the authority over the other parts, right? I mean, it's one thing to say that they have to do something with it. It's another thing if they're interpreting the language that their authority has been removed from the process with regard to this. And I don't think that that's what you're saying, but that's what we have to work through.
Understood. Thank you.
All right.
Okay, we're going to go to Senator Washington.
Thank you. And thank you, Senator Augustine, for raising that. I read this additional H and J, it says shall process. So there's a may versus shall. So it says shall process. And so the interpretation of what process means. So process, the counties are saying process means take it through, right? And you're saying you're not saying that. You just want a decision made one way or the other in a reasonable amount of time. Would that be correct? In other words, I'm not sure how the bill will, if that's your answer, I'm not sure how the bill helps your case if the counties decide that, okay, it's great, we have the authority and no. So
Well-
they stay, which I think we believe that that's still within their right to do. So I'm trying to understand if it's not trying to require that the locals abide by the checkoff that the PSC says that there is a certificate for public convenience necessity, which is another thing, and we'll have that described exactly what that is. So if they're saying, okay, check that box without all the other conditions that the locals are required to use when they're deciding permanent, or even when the PSC is using. And now we also have environmental justice impacts. We have a number of things that have to go into consideration of the sightings. So I just want to get on record that the locals would still, as well as the PSC, still be able to take into account all of the things and not simply whether or not you filled out the form correctly, but all those other things are allowed to be used.
So I think one important thing to keep in mind, Senator, is the distinction between the CPCM process and then these local permits. So the Supreme Court of Maryland has said that the overarching permit to construct, the discretionary permit that decides whether or not a project will happen in a particular location, that's done through the CPCM process. That's issued by the Public Service Commission. As part of that process, and this is all laid out in statute, they have to consider many different environmental, socioeconomic factors. They have to consider consistency with zoning, comp plans, the position of the local government. There's a bunch of different ways the local government can participate in that process. But ultimately, the commission issues the CPCN and it says whether or not the project is approved for that location. These permits we're talking about that are subject to this bill are the follow-on non-discretionary permits. So when a project applies to these permits, it's have you met the county's and the state's requirements for instance, stormwater, which are very technical. It's really engineers reviewing these. You look at, how the runoff is from the site, things like that. If a project doesn't meet those requirements, absolutely the county would be expected to deny that permit. But if the project has satisfied them, then the county would need to approve it. So the point is that the county has to move forward with the process. It has to apply the standards. And if the project doesn't meet the standards, it could be denied. But that's different than the initial decision of whether or not the project can happen at all, right? So there is sort of a distinction there. Hopefully that was useful, but.
In the bill, the language just says notwithstanding any local law, a county or municipal corporation shall process within a reasonable time any local permit required under, so they're already assuming that certification process has happened. And now it's saying, we've done this, now you must do X. And so I do understand what the bill says.
Okay, I think what's become clear to me is listening to Ms. Smith, you guys, and then the locals. I think there even is a different reading of perennial. You may think it's clear cut case law. I'm not sure from what I'm hearing that the reading of that case is exactly viewed the same, but I think the end result is it may take the General Assembly to clarify some of this here in this committee. So any other questions for this panel before we move on to, we do have one virtual witness.
Yes.
And Maureen, we're gonna pull up Mr. Posner, who I had called originally. Hopefully he's still on the line. Okay, Mr. Posner, we see you. You're okay, and you've got 2 minutes.
Thank you so much. I'm zooming in from home. I apologize that I was not able to be there in person. I'd like to just mention first parenthetically that the Sierra Club also is a strong supporter of the previous bill that was discussed, and you can find the explanation for our position in our written testimony. With regard to this bill, we also are urging a favorable report. The central concern of the Sierra Club has to do with the progress of solar development in the state. Unfortunately, for a variety of reasons, that development is lagging. The General Assembly and the Renewable Portfolio Standard says we're supposed to get to 14% of our consumption would be solar by 2030, but we're actually not on course for achieving that. So a key component of moving forward with actually achieving the goals that the state has set is these utility scale solar projects, in addition, of course, to rooftop solar, community solar, and the other types of solar that we have. So it's important that these utility scale solar projects move forward. We have a very clear and organized step-by-step process that's been described by the other panelists, the CPCN process, followed by the local permit. So our concern is that progress, is that system, that process continue and move forward in an organized and clear fashion. So this bill seeks to make sure that after the CPCN is approved, there aren't any missing links in the process that suddenly throw a project off course after it's been approved and by the Public Service Commission. Thank you.
Okay, any questions for our virtual witness? Okay, seeing none, thank you. So that's done with our proponents. We're going to next go to, we do have one unfavorable, Dominic Butchko from Mako. Tom, why don't you come up here? You signed up unfavorable, and under the new rule, you got 2 minutes.
Mr. Chair, members of the committee, Dominic Butchko with the Maryland Association of Counties. So our written testimony addresses the bill that was drafted. And actually, I think that was a few versions ago because the one online recently changed as well. Hearing the intent of the bill sponsor and the advocates, I think that there's definitely a middle ground that we can find. I know that one version of your amendments did go to our county attorneys and there was some disagreement in the interpretation. I know the latest version didn't get out as widely because we just got it. And again, there is some difference in interpretation there, but I'm confident that we can find a middle ground here. Counties don't want to be the ones holding these projects up. And we do think that it's just some technical things we need to clear up there. So, Mako stands ready to work with you and to get this solved.
Okay, well, that was very good testimony there. Any questions for our witness? Okay, seeing none, that concludes the bill hearing on Senate Bill 489, which we're going to next go to Brooks Part 2 here, Senate Bill 443, and we do have Lisa May, Realtors, your sponsor panelist. She's your lone designated. We do have one other witness signed up favorable, but okay, Senator Brooks, Senate Bill 443.
Thanks, Chair. Chair Feldman, Vice Chair Kagan, and members of the EEE Committee. Thank you for the opportunity to testify before you on SB 443. For the record, I'm Senator Brooks, representing the 10th Legislative District in Baltimore County. SB 443's real estate brokers, salespersons, and associate brokers continuing education courses alternatives. The purpose of this bill is to establish a separate continuing education requirement for real estate brokers, real estate salespersons, or associate real estate brokers licensee who has been issued an initial license by the State Real Estate Commission. All real estate licensees must take a 60-hour pre-licensing course and pass a state exam in order to receive a real estate license. Once they have a real estate license, they are required to take continuing ed classes to be eligible to renew their license every 2 years. SB 443 creates a more practical continuation education requirement for new real estate licensees during the first licensing period. After the licensee would take the same licensing class as the rest of the licensee base. After taking the 60 hours of pre-licensing exam and passing tests on the national and state content. Many new licensees have never been exposed to or had an opportunity to read a real estate contract or experience making an escrow account deposit. The new requirement will provide an opportunity to further educate new licensees on the contract, advertising rules, handling of escrow money, landlord-tenant law, financing, and a myriad of other issues that arise when clients are looking for property. For this reason, I'm requesting a favorable report. Okay, now I'll turn it over to my one panelist.
Okay, why don't you go, Ms. May?
Thank you, Senator Brooks. Thank you, Mr. Chair, Madam Vice Chair, members of the committee. Lisa May with Maryland Realtors. As the senator mentioned, this bill is intended to create a base level of practical education for new real estate licensees. Our current CE requirements treat all real estate licensees the same, whether they've been in the business for 20 minutes or 20 years. We think that new licensees need specific training because real estate theory that they learn in pre-licensing is very different than the practical day-to-day work of being a real estate licensee. It doesn't impose any new costs, new hours, new timetables on licensees. It merely takes the existing 15 hours of CE. And instead of having that be a mix of required and elective classes, it makes them required classes on the practical aspects that Senator Brooks outlined. We think that this increases the professionalism and knowledge of the industry, and we ask for your support. Thank you.
Okay, any questions for either the sponsor or our lone or sponsor panelist witness? Okay, seeing none, thank you. We only have one other witness signed up. We've got Donzel Brown. Is Donzel Brown here? Going once, twice, Donzel Brown signed up in person, favorable. Okay, it doesn't appear Mr. Brown is here. That concludes the bill hearing on Senate Bill 443. We're going to go, Senator Brooks, why don't you take a little rest because we're going to go a little bit out of order here because we've got some chiefs of police here in the audience. And I apologize, fire chiefs from two of our counties, two fire chiefs in the audience. We're going to take Senator Augustine's bill next, which is Senate Bill 414. And I'm going to just call up, we've got a number of sponsored panelists designated here. I don't know, Senator, if you have a particular sequence, because you've got a number of witnesses. I'm going to call up all the folks you've designated and I'll let you pick the sequence here. But Grant Walker, Harvey Woods, Dominic Butchko, Tawana Allen, Joanne Runn, Tiffany Green, Jonathan Dayton. There are other witnesses signed up favorable. They haven't been designated sponsor panelists. We'll call them up next. So Sarah Augustine, I'll let you explain and then you'll identify the sequence you want the witnesses after you. Okay. So you've got the time you need.
Thank you, Chair Feldman. Senator Malcolm Augustine here for Senate Bill 414, Commission to Advance and Strengthen Firefighting within Maryland. Mr. Chair, thank you so much for the accommodation since we obviously have a significant group of people here who are leaders of our first responders. And my first thing to say to all of them and to all of our firefighters is thank you. Thank you so very much because we are indebted to you. You are willing to put your lives on the line for us every day. And I just really am grateful for that. So I just say thank you so much for that. I got to say, because in my district, includes, of course, the Prince George's County Professional Fire and Emergency Medical Services Department. In my district as well, though, I do also have volunteer fire departments, Bladensburg 9, Brentwood 55, Chapel Oaks 38, Chillimadelphi 34, Kentland 33, and Mount Rainier 3, all who serve inside of my community. And all of them I've worked with all of them through the years. I've just been really grateful because we've gone around to the community and I've worked with them together, distributing smoke and carbon monoxide detectors, saving lives. They've also just been so accommodating of a request to use their facilities, the latest being a toy drive that we had in our community and at Bunker Hill in Brentwood for the less fortunate in our community. They give and give and give and give to our community selflessly, but they also, many of them have shared with me the challenges of trying to keep our community safe while having to take on so many extra shifts because we just don't have enough first responders. So this bill seeks to do something about this crisis. So what this bill does is it establishes the Commission to Advance and Strengthen Firefighting within Maryland to study and make recommendations regarding the effectiveness and viability of certain incentives. And if further goes on, really to look at what we need to do to attract, the support, and retain individuals in firefighting in our state, and requires the Commission to report its findings back to the General Assembly by December 1st of 2023. So we know there's some real urgency, so we want to do something about this right now. An adequate and responsive firefighting service is critical to functioning in our society. Vice Chair Kagan, as you well know, when we call 911, we have a basic expectation of speed and quality of service that we depend on them for them to be able to do that. Now, today, our firefighter service is able to meet the demand, the current state of recruitment and retention point to a troubling future. This is an issue not only felt in Maryland, but it is a national problem. I mean, this is a national issue. It's a national issue. For several years now, both career and volunteer firefighting services have seen a significant number of retirements, which have outpaced the number of new applicants, represents a dramatic change from a traditional norm of well-staffed firehouses. Historically, firefighters have been a core pillar of our communities, as I mentioned, and really have represented that the connection to so many that we are so grateful for. Senate Bill 414, it's a critical piece of legislation, and it seeks to address this negative state right now that we are having to contend with in firefighting with regard to recruitment and retention. And as you can see right here, we got a really broad coalition from folks across fire service who are in support of us getting ourselves together to figure out and get some solutions to this. I will share with the committee and Senator Gallion, he had mentioned this to me already as well. There is an amendment to be contemplated that would make it more inclusive to include emergency medical service providers, as you mentioned to me, and first responders more wholly. And it's in the content, but we can make it more explicit because we are really looking at all of these folks who put their lives on the line for us every day. And we just really need to support them. And so that's what this bill does. And with this in mind, I'm going to ask for a favorable report on Senate Bill 414. And I guess just because I don't want to get into any trouble with all of them, we're just going to work from this that way.
Okay.
If that's okay.
So we're going to start there. Sir, tell us your name, and each of you will have 2 minutes, but why don't you start off, lead off.
Thank you, Chair. Good afternoon. My name is Grant Walker. I am the 1st District Representative from the Professional Firefighters of Maryland, representing the nearly 10,000 active and retired IFF members in the state, and a Vice President of the Prince George's County Professional Firefighters and Paramedics Association, IFF Local 1619. I am a lieutenant in the Prince George's County Fire and EMS Department. The National Capital Region is home to 5 of the nation's busiest fire departments. Our state's fire departments continue to grow, rising to meet the challenges of their changing communities. Our firefighters and EMTs are the backbones of these fire departments. Faced with astonishing hospital wait times, increased demand for service, and facing the very real possibility that they may not be able to go at home at the end of a shift, our firefighters and EMTs continue to come to work every day, ready to serve their communities. The fire service now includes 4 different generations, all with different life experiences and challenges. With digital natives entering the workforce, it has become imperative that as public service entities, we innovate our systems of recruitment, hiring, and retention. When you can earn a 6-figure income from the comfort of your couch, it has become a pastime that we find a way to bring the next generation of firefighters to the kitchen table and keep experienced leaders from leaving prematurely. This commission is critical to addressing the needs of today while anticipating the problems of tomorrow. Due to staffing shortfalls and retirements, our firefighters are working more hours than ever before begging just to be able to go home at the end of their shift for their families. Recent data shows that Maryland's firefighters are suffering the most burnout in the nation post-COVID-19, and it has led to significant behavioral health challenges that we must make every effort to address every single day. In this room are labor leaders, fire chiefs, firefighters, and municipal governments. It is rare to see this broad coalition in the same room at the same time advocating for the same thing. This alone should show you how important creating this commission is. Our fire departments are stretched to the limit. We must find a better way to recruit, hire, and retain firefighters in Maryland. I ask this committee for a favorable report on Senate Bill 414. Thank you.
Okay, thank you, sir. Why don't you pass that mic to your left? Yeah.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. My name is Kate Lovelace, and I'm the Executive Director for the Maryland State Firemen's Association. I've submitted my written testimony in favor of the passing of Senate Bill 414, and I thank you for the opportunity to speak with you today. I have actually been replacing Jonathan Dayton as he was unable to make it here today. I have been a member of the Volunteer Fire Service for almost 20 years. I have been a firefighter, an emergency medical technician, and most importantly, I've been a volunteer recruiter. I worked for the Prince George's County Fire Commission as their volunteer recruiter prior to coming to the MSFA, as well as serve as co-chair of my own department's Recruitment and Retention Committee on the Eastern Shore. I'm here today to show my support and respectfully ask for your favorable report. I, along with the MSFA Recruitment and Retention Committee Chair, Jonathan Dayton, will be appointed to this commission by MSFA President Ben Kurtz, if passed, to represent the MSFA and over 30,000 volunteer fire service personnel across the state of Maryland. We look forward to assisting the members of this commission in conducting this very important and much needed study. The recruitment and retention of firefighters is in crisis. We all know this. Both volunteer and career recruitment is at a critical crossroad. If we do not do something now to ensure the survival of the over 350 volunteer fire departments in Maryland, we will continue to see a decline in response rates, increase in loss of life and property, and the invaluable contributions that our volunteers provide to our citizens will cease to exist. Volunteer fire, EMS, and rescue personnel save the state of Maryland billions of dollars each year, but that does not mean that we can do this alone. This study will allow crucial conversations to occur. It will create dialogue on where we go from here, and it will bridge the communication gap between our lawmakers and volunteer and career fire department leadership. A favorable vote today will create a pathway of success for our future. Thank you.
Okay, thank you.
Good afternoon, Chair, members of the committee. My name is Lieutenant Tawana Allen, and I am the Recruitment Manager for Baltimore County Fire Department. I am responsible for recruiting and overseeing the hiring process for the department. Over time, we've seen a decrease with the number of attendees at our career fairs, thus resulting in lower numbers of candidates that apply. Over the past 3 years, while I have been in this position as recruitment manager, I have seen a 25 to 30% decrease in applications. After distributing a retention survey to current and past fire department members, it was found that there were multiple areas of concern that greatly affected their interest to stay with the department. The creation of this committee will be most advantageous for the future of fire departments in the state of Maryland. We will be very thankful for a favorable vote to create a commission to study practices employed in other states to attract, support, and retain individuals will greatly enhance Maryland's ability to create a sustainability plan for the future. Thank you for your time.
Okay.
Good afternoon, Chair and Madam Chair, and Chair members of the committee. My name is Joanne Rund. I am the Fire Chief for Baltimore County Fire Department. Our department is considered one of the largest departments in the state of Maryland, and we are a combination system, which means we are comprised of career and volunteer members. We host over 1,000 career members as well as 2,000 volunteer members, 25 career fire stations and 29 volunteer stations, just to give you a volume size. As one of the largest combination systems in the state of Maryland, we provide fire, emergency medical services, and rescue services to our citizens and visitors. Our department is experiencing a serious recruitment and retention challenge within. This is not unique to Baltimore County, nor is it unique to the state of Maryland. However, the creation of this commission to study the practices employed by other states to attract, support, and retain individuals will greatly enhance Maryland's ability to create a sustainability plan for the future. I look forward to a favorable vote and recommendation towards the development of this commission. Thank you for your opportunity and for my chance to share my feedback.
Good afternoon. I'm Tiffany Green, Fire Chief of Prince George's County Fire and EMS Department. As the Chief of Prince George's County Fire and EMS Department, which is the largest combination department in Maryland. No competition. Love it. I appreciate the interest in the fire service and willingness to discuss creative solutions to the current struggles with recruitment and retention, and I'm willing to support this bill however possible. How will this bill help us? It will identify the barriers to recruitment and retention statewide to be able to provide resources as needed. Mental health and wellness is a common topic and major reason for attrition within this profession. Additional research is always needed for allocation of new and innovative support programs. Workload distribution, staffing, and burnout is common in our county, running nearly 300,000 unit responses in 2022. That's approximately 150,000 calls a year. Increase in training, certification standards are necessary and an additional challenge for both volunteer and career staff in the current setting. Specifically within our county, we have begun to look at updating our volunteer training standards, which haven't been updated since 1997. This bill has the potential to identify and resolve staffing, retention, and firefighter well-being concerns that will ultimately make the fire service more conducive and supportive of the growth and expansion of Prince George's County and the state of Maryland. I look forward to your favorable review and acceptance of this bill. Thank you.
Okay, before we go to some additional witnesses who signed up, Senator Augustine, if you want to come back up to the podium, any questions for the sponsor or any of the sponsor panelists here? We've got Senator Kagan, Vice Chair Kagan.
Thank you, Mr. Chair. So I have a statement and then a question, if I could. So colleagues, I just want to flag Chief Green, Chief Rund, and not with us today is Chief Wolford from Anne Arundel County. They are three smart, hardworking, effective women chiefs, and they have been not only remarkable role models and leaders, but the four of us have been working with a lot of other allies to make sure to finally change the Maryland State Firemen's Association, the Maryland State Firefighters Association, as 43 states and the International Association has already done. So hopefully we're going to get that under President Ben Kurtz. Hopefully we're going to get that done this year. So thank you for all you do to inspire young girls and young women to become fire chiefs and leaders. With that, Senator Augustine or colleagues, totally agree that this is a huge problem. But as you know, our firefighters are not the only place where we have crises. And I wonder whether there's any conversation. I mean, do you want to keep this as just firefighters? Because we also have enormous shortfalls in police, in fire, in paramedics, and in our 911 specialists, the courageous women and men under the headsets. And I wonder if you would reflect on, or if you know an answer to, expanding this a little bit and collaborating on ideas as to how Maryland can do better with our recruitment, training, and retention of all of our first responders.
So what I would say is that while I am supportive and actually have sponsored other such matters that are a little bit more specific, I think that what we know is that this is what I think is important is that the issues and the concerns for the firefighters and for this particular group of folks, it's very acute, number one, and it also is one that has its own unique characteristics that others don't have. Okay, these folks run into burning buildings. I mean, like that's just different, right? So to try to put that with the other, things, I think that they're very unique. They really do deserve to have that real neat, unique focus just based on the fact that their profession is different than any other.
Thank you, Senator.
Okay, we're going to go to Senator Carrozza, then we'll go to Senator Brooks.
Thank you, Senator Augustine, for this bill. Proud to co-sponsor it. And just a little context, and I'm sure my colleague, Senator Gallion, as a volunteer fire chief in the past, but I have 20 fire companies and departments in my district, 3-county district, 11 municipalities. I probably spent the past several weekends attending the annual award ceremony for each one. Obviously, we spend a lot of time talking about retention and recruitment, and it is an urgent situation. And when I saw that it was actually the Maryland State Firemen's Association with MACO, with the professional firefighters, I have to tell you, I was really encouraged. However, part of my reaction was, okay, we need to have this group. We need a sense of urgency to make the recommendations, and we need to move. Losing up, it's going to take a session to do that. So I said there should be some bills this session that we support, which I think a lot of us are, to just kind of bridge. My question is, and I think it's really to the Maryland State Firemen's Association, the professional firefighters, to the extent that you all can really prioritize and what those top, what the top 5 recommendations might be, and actually have consensus on that. And maybe you already have some, ideas of what they are. At least I do from talking to some of the ones on the front lines. But when I talk to my local volunteer fire companies and the professional firefighters, they all have like these great ideas. And I tell them, please make sure you're feeding them up through your leadership. So those ideas are at the table and there's a sense of prioritization. So I guess I'm asking the representatives, the leadership of the professional firefighters and the Maryland State Firemen's Association, so, volunteer and career, how can you make sure there's a consensus and a prioritization so we can move forward with consensus and a sense of urgency?
I can take it if you want. It doesn't matter.
Well, the only comment that I would have is that's why this study is so important, because it does bring all of those entities together so we can have that conversation, because the conversation has not been. It does happen on lower levels. You have volunteers and careers working together on shifts or working within the same fire department, and they do have the conversations. But you're right, it does need to move up to those people who are going to be crucial in getting change move forward. So that's why I think this study is going to be.
We all
the
agree
best
on the
thing.
study.
Yeah,
I guess
so-
where I'm challenging you a little bit, I'm just asking that, is there a way that these folks on the front lines, I was at Ocean City's annual event this past Saturday, Berlin the week before, and they, is there a way, or can you actively make the effort to make sure those ideas are going up to you all at this level? And that's the same for the professional firefighters, because they're not really always good about, they might talk to me and I'm encouraging them to follow up through the MSFA leadership or the professional firefighters. But I guess I'm asking you, can you make an active, proactively go and pull those ideas so we have everything and we can, and I like to believe that you all can prioritize those issues.
Let me try to answer that. So I'm with you on that, Senator Carroza, and I think that the testimony was that they're committed to doing that. That's what you're asking for. What you're asking for as far as like the ideas coming up. I mean, we have a broad cross section of the people who are to participate on this commission to ensure that those kinds of ideas do come to the top. Okay. So if you look at the list of those who are set to participate, that's the whole, like the point of that. And that we will have this coordinated effort with the Department of Labor at the middle of it, making sure that those things do come forward. And so I think that really is the essence of what this is about. It is about, and it is different, where we are able to get some of the best ideas from volunteers on the Eastern Shore, some of the great ideas from professionals from Prince George's County, Baltimore County, and have this group all come together because there is a common consensus amongst them all that this is a crisis. Let's bring our heads together, right? And collectively come up with strategies that's going to work across the state. That really is the bill. That's what it is.
I agree with all that, but I think for it to be really successful and to move on is that once you have that coming up, and it's, and in my case, I can point to Salisbury and Ocean City that are career and volunteer, and some of those that, see how they work together. But then to me, it's really crucial that the players at this level, if you all then can agree on what those top priorities are, that to me is where we're actually going to make real progress on retention and recruitment.
And I think that's where we lie with our, being in favor of this legislation, because once it is passed, hopefully once it is passed, we'll be able to poll our departments and say, what are your top 3 or top 5 challenges that you're seeing, and bring them to the table. That's what our goal and our mission is for the volunteers, is to gather that information, bring it back to this panel and this study, and create that coalition of forces that will face those challenges together across volunteer and career.
And I'll just close here, and Senator Augustine, with the end result that we would have not just the challenges, I think we know that, but we actually have clear recommendations that would be prioritized.
Yes, absolutely. That is exactly what the intent and what we're going to be seeking through the commission, and the report that they are to provide to us at the by December of 2023.
Okay, Senator Brooks.
Thanks, Chair. No question. It was all favorable. Just one amendment. Just want to give a shout out to my chief, Chief Run, Baltimore County, and also Lieutenant Allen. Okay.
Thank you.
That happy note. I don't see any other questions. We do have a few other witnesses signed up favorable. I'm going to call them up. It's Harvey Woods here. Mr. Woods. And Victoria Venable. Victoria.
That should actually be
Oh, okay. Well, come on up. Wait, who, Chief? No, Victoria. Okay, fine. And then Dominic Butchko. And I think that wraps up the signed up witness list. So, sir, why don't you tell us who you are, and then you've got 2 minutes to present your testimony.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. In the air of time, I'll keep this short. My name is Tom Coe. I'm the Fire Chief for the Frederick County Division of Fire and Rescue Services. I have lots of words typed out to share with you, but they're very consistent with everything you've heard from here on out. With the other leaders of our fire service in Maryland, on behalf of Frederick County government, I just urge a favorable report on Senate Bill 414.
Okay, sir.
There was a May 2 if I never heard one. Thank you. Mr. Chair, Madam Vice Chair, members of the committee, I apologize for having a cold. And rather than drag you all through my remarks with my voice today, I will simply say me too.
Sir. Oh, okay, but tell us who you are. That would be important. What's your name?
I'm sorry, for the record, Harvard's Maryland Fire Chiefs Association.
Perfect. Thank you, sir. Dominic?
Mr. Chair, members of the committee, Dominic Butchko with the Maryland Association of Counties. Me too, if I ever heard one as well. I also just want to point out that this is MACO's one of our top 4 legislative initiatives for the year. This is a really big issue. It's really important, and we urge a favorable report. Thank you.
Okay, thank you. Any questions for the panel? Okay, seeing none, that concludes the bill hearing on yes, sir.
Mr. Chairman, I almost overlooked something.
Yes.
I'd like to offer congratulations to Madam Vice Chair on the occasion of her receiving a prestigious national award for her work in keeping our 911 systems out in front. Thank you, Madam Vice Chair.
Okay, well, thank you for that. We're all proud of her. Thank you for bringing that up, sir. And that does conclude on that high note, the completion of Senate Bill 414. Senator Brooks, why don't we go back to you now? And we're going to take up Senate Bill 614. And I'm going to call up a number of your sponsor panelists. We've got Jeff Parks, Kirk Snyder, Thomas Skinner, Eli Howard. I see Thomas Killeen up there, and Jeremy Zedek. So that's 6 witnesses. We've got 5 chairs. So one of you are going to have to take the front row seat, and then we'll catch you when somebody's complete. So Senator Brooks, why don't you lead off, and then we'll go to all your sponsor panelists after that. Senate Bill 614.
Chair Feldman, Vice Chair Kagan, and members of the EEE Committee. For the record, I'm Senator Brooks. I represent the 10th Legislative District in Baltimore County. Thank you for the opportunity to testify before you on SB 614, that's public safety, fire dampers, smoke dampers, combination fire and smoke dampers, and smoke control systems. The purpose of this bill is to establish requirements for the installation, inspection, and testing of fire dampers, smoke dampers, combination fire smoke dampers, and smoke control systems. And sprinklers and fire extinguishers are not the only way to prevent the spread of fire in a building. Smoke and fire dampers play an invaluable role in preventing the spread of fire and toxic fumes through HVAC ducts. However, there are very few rules regarding the installation and inspection of these systems. According to the University of Maryland Department of Fire Protection and Engineering reliability study published in 2021, out of the 150,000 fires and smoke dampers inspected, 80,000 or 53% required some type of repair. This study reaffirmed the importance of periodic inspections. SB 614 provides clear guidance to commercial building owners and HVAC professionals on the proper maintenance to keep these dampers and control systems in working and safe conditions. The bill conforms Maryland to the evidence and the approved standards of the National Fire Protection Association. A number of municipalities, such as the Pittsburgh and Philadelphia, have already implemented these standards. Further, both Delaware and Illinois approved similar regulations unanimously. While I acknowledge the impact this will have on some commercial owners, these inspections and installation requirements are a matter of public safety. Failed smoke control systems have made several deadly fires worse than they otherwise should have been. In the 1980, many of us witnessed the MGM Grand Hotel in Las Vegas that took the lives of 85 guests and injured 600. Yeah, these deaths were caused largely in part due to smoke inhalation. On June 14, 2017, the fire at the Grenfell Tower in North Kensington, West London, took the lives of 72 occupants. Investigative reports revealed that an insufficient damper system contributed to the fire. Investing in this change now will keep our commercial buildings safer and help protect lives of Marylanders. For these reasons, I request a favorable report. And we do have a panel.
Yeah, why don't you, do you want to do like the Senator Augustine did, just go, or do you want to?
Yes, I will. I'll
Can I go this way?
yes.
Do you mind if I start?
So that's totally fine. What you're going to start, and then we'll go down the aisle. So you tell us your name, and then each of you has 2 minutes.
Good afternoon, Chair Feldman and Vice Chair Kagan and Senate committee members. Thank you for allowing me to provide oral and written testimony on SB 614. My name is Tom Killeen. I'm a business representative for Smart Local 100. For 25 years of my 42-year career as a sheet metal journey person, I performed testing, balancing, and commissioning of mechanical systems, in addition to holding 3 certifications in the TAB field. During my career, I've witnessed several hundreds of fire life safety dampers that don't operate correctly. A fire damper reliability study was done in 2021 by Dr. James Milkey, a national respected professor and chair of the Department of Fire Protection Engineering School at the University of Maryland. The study has been submitted for your review. The study concluded that 67% of all buildings in the study had issues with fire life safety dampers because there's such a prevalent problem with fire life safety dampers. There is a real need for individuals that will test fire life safety dampers to maintain a certification under ANSI in doing this work. Currently, sprinkler systems, fire alarm systems, and fire extinguishers are supposed to be tested periodically to guarantee that they work properly. Unfortunately, other components such as fire life safety dampers are not clearly subject to inspection and testing requirements. Fire life safety damper legislation has been passed recently in Nevada, New Mexico, Washington State, Illinois, Delaware, Philadelphia, Pittsburgh, and 20 different municipalities in Ohio. There are another half dozen states that have introduced legislation this year. Finally, the opponents of this bill will tell you there's an astronomical cost associated with Senate Bill 614.
Under the adopted Maryland Fire Prevention Code, fire life safety components are required to be tested at irregular intervals. If this testing is already being done, there should be very little fiscal impact. If, as Dr. Milky's study has shown, the testing is not being done, then fiscal impact would be justified to ensure the health and the safety of Maryland public, just like any other fire life or safety test being required. I ask for a favorable vote on Senate Bill 614.
Okay, before we do that, you got to tell us what ANSI is, because Senator Kagan. Yes, ANSI. What does that
ANSI.
stand for?
ANSI is American National Standards Institute.
Excellent. Okay. Sir, you're going to go next and tell us your name, and you get 2 minutes.
Chairman Fellman, Vice Chair Kagan, members of the committee, thank you for allowing me to speak in favor of Senate Bill 614. For the record, I am Tom Skinner. I'm the first Vice President of the Professional Firefighters of Maryland. I also am a career fire lieutenant with the Baltimore City Fire Department, where I've served for almost 32 years. This bill, I'm going to be brief. You have my written testimony. This bill is about preventive maintenance. We all know that if we do not perform preventive maintenance, things go wrong. The things that go wrong here cost lives. The 70% of deaths in fires are due to smoke inhalation. Senator Brooks spoke to the MGM Grand Hotel fire and to the Grenfell Towers fire in London. In 1991, the Philadelphia Meriden Plaza had a similar situation. They had limited exposure because the building was all but unoccupied. The crisis there was 3 of my brothers and sisters died. In the MGM Grand Hotel, 700 injured, 14 of them were firefighters. This is an issue. The reliability study that was performed right here in Maryland at the University of Maryland covers all of the questions that we have. Our goal here is to make these buildings safe for Marylanders and safe for your first responders and your firefighters. I urge a favorable recommendation on Senate Bill 614. Thank you.
Okay, thank you. Okay, we'll go next. Sir, tell us your name.
Good afternoon, Chair and committee members. My name is Eli Howard. I'm the Executive Director of Technical Services for the Sheet Metal and Air Conditioning National Contractors Association in Chantilly, Virginia, better known as SMACNA. We are an American National Standards Institute developer of standards, and SB 614 references and will reference standards that our association, and specifically myself, was a voting member to help participate in writing of the standards, specifically National Fire Protection Association Standard 90A, 90B, 3, and 4, which all reference against National Fire Protection Association Standard NFPA 80 and 105 for the inspection and servicing of fire dampers. Further, I'm a voting member and have been for some 15 years now on the International Mechanical Code Committee. That is the mechanical code that is actually adopted by the state of Maryland and all 49 states, basically, all 49 bar California, to use the International Mechanical Code as their basis for the design, construction of all commercial institutional facilities in the state. That document references against NFPA 90A, 90B, NFPA 80 and 105. In essence, this information is there. It's adopted by the standards, adopted by the state. And what we need to see now is the enforcement of that. I look at this like a 3-legged stool. We have sprinklers in this building. We have a great elevator system in this building that are inspected on an annual basis. That's required. Make sure our sprinkler systems are working, make sure our elevators are working. The last piece is the fire and smoke dampers. That's the 3rd leg of the stool that's not being inspected right now. So we basically have a stool with 2 great legs and 1 leg that's pretty shaky. So we ask for support of SB 614. Thank you.
Okay.
Good afternoon, Chair, Vice Chair, esteemed members of the committee. My name is Kurt Snyder. I'm the Executive Director of the Sheet Metal and Air Conditioning Contractors National Association Mid-Atlantic Chapter. We're right down the road from NASA and Greenbelt. I come here today to support all these other professionals before me in support of SB 614. This is the highest importance of what we face right now. By the sheer numbers of failed dampeners around us, we can almost presume in this very building we're sitting in event of emergency, some of those will fail. We don't know for sure, but that's why it's so important to address those issues, excuse me. And in closing, I have also submitted my written testimony. We must not give a chance to smoke to always have the lead on all of us. For instance, the best way to put it is the smoke, we cannot let it create the labyrinth and be also the minotaur within the labyrinth. This is against our first providers. The support of our first providers, emergency personnel, and all Marylanders. So our association is in favor of SB 614, and we ask for a favorable report. Thank you.
Why don't you pass it?
Chair, Vice Chair, members of the committee. Thank you for giving me the opportunity to give my favorable testimony regarding Senate Bill 614. My name is Jeff Parks. I work for CMC Sheet Metal, a local union contractor, and I've been in the sheet metal HVAC industry for nearly over 25 years. As a Maryland HVAC contractor that employs certified fire and smoke damper technicians, we performed damper acceptance and inspection testing on many buildings throughout the region. We can attest firsthand to the pervasive issues with fire life safety dampers as documented in the University of Maryland study. On too many occasions, dampers have been installed incorrectly, had no or limited access, broken fusible links, debris blocking damper blade function, broken damper shafts, inoperable actuators, the list goes on and on. Many times these noted deficiencies resulted in the need to repair or completely replace the damper. As previously stated, I'm in full support of this bill, and I believe that this will make Maryland buildings safer for its occupants and help prevent future tragedies and possible loss of life. Thank you.
Okay, Mr. Zedek, I'm sorry. Yeah, sorry.
Surprised.
Right.
Chairman, Vice Chairman, and members of the committee, I appreciate your opportunity to testify in front of you today. I have submitted written testimony, so I will try to make my comments brief and as quick as possible to get through what I wanted to say. My name is Jeremy Zedek. I'm with the National Energy Management Institute. We're jointly funded by SMART and SMACNA. We do a lot of training and certification around the country, and this is one of our biggest issues. Harvard University created the 9 foundations of a healthy building. And the presumption there is that when you walk into a building, certain things are going to work properly. In this case, fire life safety dampers, fire security systems, sprinklers, things like that. When you get into an elevator, you're pretty sure that it's going to go up and down safely, right? And that's because these things are inspected by professionals. What we're trying to do here is to bring that sort of attention to fire life safety dampers and smoke control systems, because like was mentioned before, sprinklers are an important part of that 3-legged stool, but they protect buildings. Fire and smoke dampers and smoke control systems protect the people. When you're running in and out of a building, when there's a casualty, you want to be able to be assured that when you go to press that door to go through into a stairway, that door is not going to have so much pressure on it that you can't open it. Right. And then when you're in that stairway and you're trying to get out, you want to make sure that smoke isn't coming in and choking you so that you can get out safely. And when the first responders that came in earlier to talk to us, when they're running into a building to save lives and protect people and equipment and things, that smoke should not be in that stairway. They should be able to use that as a safe haven to go fight the fire and get out alive. That's what we're talking about here. So what is going on is the code protects us. It's in the code already that we're supposed to be testing these things. What we're suggesting is that's not being done, as evidenced by the fiscal bill when they've noted, we have a lot of these things and it's going to cost us a lot of money to test them. They should have been testing them already, right? So we're saying that should be done on a regular basis, and to alleviate some of the stress from the fire marshal and his people and officers out there in the HJs, have that done by skilled, trained, and certified workers with the knowledge and the skills and the training to do that safely, so that the first responders and the fire marshals and everyone else in the public has the ability to safely feel safe in a building and know that work's done right. And thank you for your time.
Okay, thank you. So we're going to go Vice Chair Kagan and then Senator Augustine for questions of either the sponsor or any of the panelists.
Thank you, Mr. Chair. I have 2 questions. First off, thank you for what you do and thank you for taking the time to be with us today. to anybody watching at home, the people who are with us make us better and help us to do our jobs better, because you guys are experts at this and we're not. So I'm not just singling out this bill and this panel of witnesses, but everyone who comes before us. If they are thoughtful and expert, it just helps us. So thank you. I have a question. I have two questions. I'm going to take one at a time. First off, in Dr. Milkey's testimony that was uploaded by Thomas Colleen, and I don't know. Thank you. So you referenced the NFPA 80. Fire dampers shall be inspected 1 year after installation, every 4 years thereafter, except for hospitals, which will have a 6-year inspection frequency. I'm wondering why hospitals are inspected less frequently than others. That seems counterintuitive.
Yeah, I'd like to defer to the subject matter expert, either Eli or Jeremy. One, two.
We flipped the coin, looks like I lost. So to be clear, the NFPA says that they would be inspected, and National Fire Protection Association, it's the standards writer for these things that are adopted into code. I apologize, just like anything else anybody does, we talk about acronyms a lot, and it's really useful. It's like, we know this stuff, and you'd probably in your profession would say things to me and I'd look at you with a blank stare. So thank you for catching me on that. What NFPA says with inspections is that they should be done when they're, initial inspection. So when they're installed, to say, hey, does this thing work right? And then for acceptance testing, which is during the process of construction, or right just at the very tail end of that, so that they say, hey, does this thing that we saw was working correctly, does it operate with the rest of the system when it's supposed to? And that's done. It's done quite regularly. You get your certificate of occupancy and you move on. The next step in that process is supposed to be 1 year thereafter. You go to make sure that still works. And the reason for that is because when things are being done in a building and you get change orders and things that you're playing with a building and you're trying to get it dialed in, things get disconnected, they get changed. There's something that's been, just adjusted or some, sometimes you see a pipe run through an opening because there's a big opening in a wall. Why not use that instead of cutting another hole, right? They're not realizing that they're stopping, they're putting it within a penetration that's designed to stop smoke. So that has to be inspected again 1 year after to make sure that something doesn't happen right after the process of building. And then from then on, it should be done every 4 years as part of the code and part of the manufacturer's installation instructions and maintenance instructions, so that you can make sure that it's working properly. The reason that hospitals, to your point, have 6-year intervals is because they have really good lobbyists. And they said, hey, we have systems that are working very well. We look at them all the time. We have a maintenance crew that's constantly involved with this. Plus, we have some infection control concerns, right? When we open up ceilings, there's the potential that we're going to have things stirring around and whatnot. And they've petitioned the NFPA to say, hey, can we have an extended period for that inspection? We can argue whether or not we agree or disagree with that, but that is the status of the code as we speak.
Again, that is informative. So you said you would argue whether or not that's wise. Give us your take. Should hospitals be on the same cycle?
I believe
Hypothetically?
they should. I mean, if we're talking about public safety, what's the difference between public safety in a hospital when there's people that are potentially sick, bedbound, unable to move?
Right.
They're high density areas. What's the difference between that and a school where, well, again, high density, but less ability to defend themselves and whatnot. So I think they're the same, but that's a battle for another day.
Or not?
Or not.
Hotels every 4 years.
Correct.
Office buildings every 4 years, colleges and universities every 4 years.
Correct.
Condos, homeowner association, apartment buildings.
Where they're installed, yes.
Where they're installed every 4 years.
Right.
So hospitals truly are a standalone?
Hospitals truly are a standalone within NFPA 80 and 105. It's also because of their accreditation process they have to go through. The hospitals, they have to give this information in once every 6 years for the fire dampers and smoke dampers to be inspected and serviced in their particular facilities. The only other entity that I can put in comparison to this for you is some in Clark County, Nevada, which is where all the casinos are located pretty much in the United States. What a lot of the casinos have been able to do there, working with Clark County, is to say, okay, we have 3,000 fire dampers in our particular building. There's no way we can get through these in this process you're looking at. So what we will do is we will go and do 25% every year. So at the end of the 4-year cycle, we've gone through and done every fire damper, and then we're going to start all over again, doing 25%, 25%, 25%. It makes it much more easier and manageable for them. In a facility like that, that is a 24/7 operation, such as a hospital. Most facilities are not 24/7, so it's very difficult. You know, you're not going to shut down the OR room in a hospital when surgery is going on to inspect the fire damper. So you kind of put it in a rotation basis, and that's what the casinos in Las Vegas have done.
With you a little, because I think apartment buildings are 24/7. I think hotels are 24/7. And I think a lot of the examples that I gave would also be 24/7.
I agree.
And the gentleman, I'm sorry, I missed your name, but the gentleman's comment about people in a hospital might not be able to be extricated as easily as those in an apartment building or a hotel. So I don't want to beat a dead horse here. I do have a couple other quick questions. First off, who is doing the inspections? Can you just be clear? Because we've got the sheet metal workers and stuff. So is it union members, workers? Are they Maryland? Like, and they're certified and?
Yeah, they go through a certification process, technicians and supervisors
Okay,
to do the work and inspections.
Under ANSI.
under ANSI, which we have defined already. So I actually have a question I will take to the senator or to all of you. Okay, I'm going to ask it publicly. Carrie's Law. I have been struggling with our fire marshal for a lot of years now. There are too many places where you still have to push 9 or some digit before dialing 911 to get an outside line. And Carrie's Law says must be able to pick up any phone in a business, in a hotel, wherever, to pick up the phone and dial 911 and get to 911. And there are places still in Maryland that are not in compliance, but we don't know because the fire marshal has not been as cooperative in inspecting. And it literally requires walking into a building and doing this and making sure that you get to 911 and saying, thank you for your time. It was a testing call. I'd love to have, I'm not going to put you on the spot now, but I would love to have a conversation. If you guys are going into every building, whether this might be a 2-second thing that you guys are able to help us do. So I'm not officially asking it, but I'm saying it out loud and publicly. The last thing I am going to ask though, publicly, and I toss this to any one of you, because I don't want to take the committee's time. All of us can always be smarter at this stuff, and anybody watching could learn. A lot of people don't realize, and we're talking about fire prevention and fire, saving lives in the event of fire or smoke. A lot of people don't know that they should close their bedroom door every night when they go to bed, and that you are more likely to save yourself if God forbid, your house gets on fire. Can one of you offer 2 or 3, max 4 little tips like that the average person may not be aware of that could help save them and their family or colleagues in the event of a fire? So close your bedroom doors when you go to sleep. Who else can add a couple other things for people's knowledge and education?
Thanks. Thanks for your support. Your bedroom doors are essential. Closing windows. A lot of these things, back in my day, when we had to walk uphill both ways to get to school, they taught you in the middle of a fire drill that you shut the windows and the doors on your way out. Get out, stay out. That's important. Get out first, then call. Don't stop for the selfies. Get out, stay out. There's videos out there. YouTube is filled with them. And a lot of those folks don't make it to the end game, but they went out live on Facebook. It's sad. But you're absolutely right. Making sure that your children are aware of where to go and where to meet you outside. Hugely important. Our fire safety division spends a tremendous amount of their time reaching out to the children. What I'm hearing is that maybe we should start reaching out to some of the adults too. We reach out within Baltimore City. I can speak intimately to. We do reach out to community associations, and we do visit community associations at their regular monthly meetings to seasonally spread the word about things like watching your step in the fall months when the leaves are on the ground, things like that.
Thank you all for being here. Thank you, Mr. Chair.
Okay, Senator Augustine.
You, Mr. Chair. So I understand like an elevator, I understand sprinklers, but I don't, how does a fire damper work? I don't even know what that is.
So Senator, I have to bring along just a simple fire damper. I'd like to just show you a quick display. Shouldn't take any more than a minute. Fire dampers are located actually in fire rated walls where the HVAC duct goes through the wall. That's where you have fire dampers. You also have fire dampers coming off shafts. Some smoke fire dampers on air handling units, but this is your basic fire damper. And what happens when there's a fire? Unfortunately, there's a link here. Unfortunately, when there's a fire, there's a link here that actually melts at 165 degrees. So when this link melts, and also these links are known to break. Yeah, watch my fingers. These links are known to break over time for being under stress and pressure. So when this link breaks, try to simulate it, the damper drops. But the damper didn't drop right now because unfortunately the drywall contractor put his track around this damper and he ran a screw in the side. So as you can see, it didn't work fully, but you take the screw out, the damper drops 100%. So that's essentially how a basic fire damper works in a fire rated wall.
Okay,
If you have the opportunity to watch any videos, and we have them on our website, that show you how a fire damper can drop, but also a smoke damper, how it can stop the spread of smoke. Because we talked about inhalation being a big problem. It often, or probably mostly happens in areas that are nowhere near the fires because the smoke is spread to other parts of the building. And to see in real time how a smoke damper closes and choked and just completely cuts off the flow of smoke to a room is very impressive. And then to think of that in reverse, when you're just sitting in your desk someday and there's a fire and before the system can catch on to that, smoke has already gotten into your space. And because of something that Thomas just showed us, now suddenly the room that you're sitting in is completely engulfed in smoke and you had no idea. It can happen that quickly.
Okay, thank you. Senator Augustine, did another, okay, any other questions for the panel? Seeing none, that concludes the bill hearing.
Chair, I just wanted to say
Yes.
that there is an amendment and
Okay.
all the stakeholders are in agreement, so.
You want to describe the amendment?
Yeah, it just makes sure that, the amendment is, say, a county municipal, we strike may, and we say a county municipal fire marshal, fire chief, or the Baltimore County Fire Chief Department, or any other designated authority having jurisdiction shall, and after marshal or local authorities responsible for the adoption of applicable fire prevention code standards.
Okay, make sure we get that amendment language. Seeing no further questions, that concludes the bill hearing on Senate Bill 614. We're gonna
Thank you.
next turn to Senator Washington.
Thank you.
On Senate Bill 382. Senator, I'm gonna call out your sponsor panel witnesses. We've got Lisa May. See you back there, Lisa. Angelica Bailey from MML. We've got Danielle Patrell, also as Maryland Realtors. Is that we've got Dominic Butchko from Mako.
Yes, I have Patrol.
Those are, we have other witnesses signed up,
Yeah,
but they're
but I
not
just
part of your
went through,
sponsor
right,
panel. So
exactly,
then we'll call
exactly.
the additional witnesses who signed up after.
Thank you so
panelists.
much.
Okay, Senator, on Senate Bill 382.
Thank you. Good afternoon, colleagues, Chairman Feldman, Vice Chair Kagan, and fellow committee members. Thank you for the opportunity to introduce this legislation to move us forward on the issue of accessory dwelling units, and is to establish a task force for us to explore this. Accessory dwelling units are typically home conversions or additions to houses. Sometimes we refer to them as mother-in-law apartments, or perhaps it's a cottage that someone is staying in. And usually it has a private entrance, and it usually has a kitchen and heating and a bedroom and a bath. So it is an accessory unit. So while it is attached to the home, it's on the property, it is considered its own residence. These are often basement or garage conversions. Some are a home addition and some are detached in the owner's backyard. This bill is in response to a similar bill that I put in last year, or maybe it was 2 years ago. It's hard to tell from 2020 to now, but it seems like it was somewhere in there. And while everyone recognizes that ADUs may be used to address our housing shortages, that it's an opportunity to increase, make housing more affordable, that it may be a way to allow seniors to age in place, and also for those interested in increasing density in some of our communities, it is very much considered a local issue and very often a zoning issue. So it is left up to individual counties and municipalities. But given that we also, as a state legislature and as an entire state, have an interest in policy that addresses the overall issues around affordability and accessibility and density. So we would like to, or I'm proposing, to put together a task force where we will gain insights into how to do it and how we can do it positively, and how we can address it both in our urban, our suburban, as well as rural communities. Now, there are a few amendments, which is why, because of these amendments, this will be a kumbaya moment. Of everyone here. First, we added urban communities, suburban, rural communities to line 5. So trying to be as inclusive as possible. We also updated the task force to be from each of these communities. So it's going to be, someone will be appointed by the Board of Directors of the Maryland Association of Counties, the Municipal League, and also the Maryland Building Industry Association, as they have an interest in this as well. We removed that the governor would appoint the members and select the chair. And instead, we felt like that the task force itself should select its chair. It has a different responsibility. We want the members to be engaged and to make sure that they're making the best recommendations possible. Additionally, we wanted to make sure and we are asking them to make recommendations about infrastructure. That's often the critique, about public service and utility needs, about how do we regulate an increase? How do we make sure that they don't become Airbnbs? I mean, I know that that is absolutely something that people are concerned about, that this is short-term rental. So we want to ensure that this is about long-term housing, which again will be delicate in that individuals have a right to use their properties as they choose, but within limits. The presence and effect of how do we address undocumented or unregistered ADUs and their potential impact, the appropriate application of building codes and safety codes and accommodations, how do we expand it? And then where do we, as the legislature and the state, provide incentives for people or groups or individuals, governments that wish to invest, and how can we leverage federal and other resources to both preserve neighborhoods? So we want to make sure that we're preserving the quality and the nature of the neighborhoods. We don't want to change substantially what you've purchased into. We don't want to turn it into many high rises or low rises all over the place. But again, be able to have a statewide set of standards so that everyone is operating, at least initially, on the same scale. So the task force is now scheduled for about 1 year and 7 months so that we can get some recommendations by the end of December so that we can take action in our 3rd year. It was previously 2 years. So we've made that amendment so that we have time to put in the bill, for it to fail, and then to try to get it to pass on our way out. And then Yeah, that's it. So, Chair, I'd like to introduce my panel, who you've already so kindly introduced. So I asked for a favorable report, and I stand here ready to answer any questions you might have.
Okay, excellent. So why don't we start with Ms. May? You want to start and then we can go to Dominic?
Yes, thank you, Mr. Chair. Again, Lisa May with Maryland Realtors. As we mentioned before this committee at the beginning of session, Maryland has an acute housing shortage. For us to begin addressing that, we're going to have to try new ideas and do things differently than we've done in the past. Accessory dwelling units can be a source of the missing middle housing units that we need if we let them be. Right now, your ability to have an ADU is based upon which county or municipality you live in. And some of them make it very difficult or even impossible for a typical homeowner to have one if they want one. ADUs aren't a new concept. In fact, they're a very traditional housing source, but we are also seeing that other states and cities across the country are having success with uniform ADU laws. They are providing new housing options more quickly, more affordably, and with fewer impacts to surrounding neighborhoods than typical new development has. It's one of the easier pieces of this puzzle we're going to find, and we really need to take some of the easy solutions when they present themselves, because the other ones are going to be much, much more difficult. We believe that housing's been deprioritized for a very long time, and that's why we have the 120,000 unit housing deficit that we have today. This bill is necessary to bring people to the table, to do more, to provide housing solutions, and to begin addressing this crisis. And therefore, we ask for your support.
Okay, why don't you go, Dominic?
Mr. Chair, members of the committee, Dominic Butchko with the Maryland Association of Counties. County support Senate Bill 382 with amendments, and I have to give a massive shout out and thank you to the sponsor for being just so sensible and working with us on this. This is definitely one of those kumbaya moments. Clearly, counties take housing very seriously. As Lisa referenced, we were all in front of you a couple of weeks ago giving a whole presentation on the things that counties are doing, and we outlined the policy tools and the successes that we're having in addressing the housing issues. ADUs have been a historically well-publicized tool in solving the affordable housing crisis, and when implemented successfully, it can be done very well to preserve and extend more affordable housing. The MACO and MML amendments, unfortunately, my colleague from MML couldn't be here, but she shares my sentiments. They serve to strengthen the use of ADUs and develop a menu of best practices and considerations. These amendments represent a balanced approach with all stakeholders and a step towards sharpening this one of many tools in solving our housing crisis. As such, MACO and MML urge a favorable report. And again, thank you very much for working with us.
Okay, any questions for Senator Washington or the panelists? We've got Senator Watson.
Yeah, just one question. And yes, it is a kumbaya moment. Done a great job looking at all the details. I know that the study will flesh out the role of HOAs in some of the various, so I won't go down that path. But the one thing I am curious about, in my mind, a rental unit is equivalent to a long-term Airbnb. And I've never been a fan of somebody telling me what I can and can't do with my own private property. So my question is real simple. Is the intent of the bill to restrict Airbnbs but allow rentals in someone's yard? Thanks.
I'm going to apologize for putting that little thing in there. I wanted to say that that is a critique. And so that would be something we would need to address. One of the things is that I know at the moment, you're not required to have a separate kitchen. In other words, it's not necessary in order to qualify as a long-term rental. You're not required for it to be actually a separate unit. In other words, you can do a long-term rental in your basement. You can do all these. So, I suppose you will join the task force and make sure that we address that. But it's one of the sticking areas, and so I wanted to put it out there. I don't have the answer, but I think for it to be, I think that the notion of transients can be a code word for a lot of things. Renter is a code word for a lot of things. And so I think we have to work around this because we are at a crisis. And please note that the implementation of these laws happened around the 50s. So there was a lot going on in our country at that time. And so, we just want to unpack all those things and sort of reset it to today's realities.
Okay, any additional questions? Okay, seeing none, we do have some additional panelists signed up. I'm just going to call the rest of the sign up list to the table. We've got Lori Graff. Lori Graff. Angelica Bailey.
Don't think she's here.
She cannot be here. Okay, yeah. Deborah Wello. Tammy Bresnahan, I see back there. And Danielle Petrell from the Realtors, although we just had Miss May from the Realtors. Is she signed up separately, or I'm assuming, I think I called her on the front end and she didn't come up. So, okay, I think that is the extent of our signed up panel. So who wants to take control here? Why don't you lead off?
Lori Graff, CEO of Maryland Building Industry Association. Thank you for allowing me to speak on this important issue. I'm not going to rehash the details. You guys, the sponsor panel did an amazing job of talking about that. And I'm not going to rehash the numbers. You guys know we have a housing shortage. It's a really important issue. We have to figure out lots of solutions. There's not a silver bullet. We can't just do one thing and create a whole bunch of new housing. We have to do a lot of little things to get there. This is just one step in the right direction. As Ms. May mentioned, it can be very, very challenging in certain jurisdictions to build these types of units. And this is just one step in the right direction. I think having all the stakeholders together, hopefully we can come together and really come up with some good solutions that move the state forward to have more housing. So thank you. And with that, we would request a favorable report. Thank you.
Okay, Tammy, do you want to go next?
Sure. Good afternoon, Mr. Chairman and members of the EEE committee, Senate committee. I'm Tammy Bresnahan. I'm the Senior Director of Advocacy for ARP Maryland. We are in favor with an amendment. We'd like to be added to the task force, but we understand if we cannot, ARP supports the availability of ADUs as an affordable, accessible housing option for people of all ages. We have done extensive work in this. As a matter of fact, tonight, we are supporting wholeheartedly in Anne Arundel County, the ADU legislation. We supported the ADU legislation in the city of Annapolis, Montgomery County, and a few other places around the state. 3/4 of those polled when ARP did a study said that they would create an ADU for a place for a caregiver to stay. I will say that in 1962, when my father died unexpectedly, my mother had 4 children. She took one room. It was already a bathroom. She added like a small kitchenette. And that's basically how we survived for the next 10 years with a little extra income. I had an aunt in Glen Burnie who did the same thing. I guess we didn't know that ADUs were illegal at the time, but it has been, I grew up in Pasadena, a little bit of a rural area, and it was just something like the gentleman said, no one told you what you could or couldn't do with your property. And so we think that this is an extension of that. We thank the Senator Washington for bringing this bill, and we ask you for a favorable report on Senate Bill 382.
Okay, our final witness, Ms. Puella.
Thank you. I'm Deborah Bilo. No problem. I am an architect. I reside in Prince George's County, and I'm here on behalf of the American Institute of Architects, the Maryland chapter. We represent about 2,000 members, 2,000 architect members throughout the state, and we are here to provide, to voice our support for Senate Bill 0382. And we also would like to suggest one friendly amendment as well. Again, I don't need to go into why ADUs are beneficial. We agree with everything that's been stated so far on why they're beneficial. We think it's been well documented through many other regions throughout the country. And our suggested friendly amendment is that we would like to bring an architect member onto the task force. We think it makes sense for a lot of the reasons that Senator Washington already brought up today. We know the building codes. We know the character of the housing stock. We know the character of the neighborhoods. We know spatial qualities. We understand how these things should be working together. And we think that it makes a lot of sense for us to be, for an architect member, maybe potentially an architect who has already been part of other conversations in other municipalities, to be part of this task force. Interestingly, I just had a neighbor in Prince George's County reach out to me last week about putting an ADU in their backyard. I gave them unfavorable news, but they have a daughter who is returning from college, and they wanted to find space for that daughter to live before she sort of moves on and moves up in the world. So I just thought there was an interesting timing of events to happen at this time. Thank you very much for bringing this bill forward. Thank you for hearing me, and please consider including an architect member.
Okay, do we have any questions for any of the panelists? Okay, seeing none, that concludes the bill hearing on Senate Bill 382. We're next going to turn to a bill that came through me at the request of the Maryland Energy Administration. So I'm going to bring up MEA. We've got Landon Farrig and Chris Rice on behalf of the Maryland Energy Administration on Senate Bill 719, Senate Bill 719. So Mr. Farrig, you want to lead off, or you want Mr. Rice? Who do you? Okay. Okay, Landon, go on. You got 2 minutes.
Chairman, again, thanks for the courtesy of sponsoring the bill. Chairman, Vice Chair, members of the committee. My name is Landon Farrig. I am the legislative liaison for the Maryland Energy Administration. Senate Bill 719 establishes a state fuel security program. While Maryland and the nation are transitioning to a clean energy economy, liquid fuels will remain a necessity for some time, and this is especially true in times of crisis. The program requires fuel suppliers to reserve and, in certain situations, direct percentages of their supply stock to wholesale resellers and even direct consumers during specific emergency situations. That specific emergency situation is a defined term under the public safety article, and that is an energy emergency. This bill will help ensure that Marylanders, and specifically critical infrastructure, have access to the fuels necessary for generators, heat, access to essential services and supplies, and it will bolster the resilience and operability of critical infrastructure in times of emergency. The program contributes positively to the resilience of the state and will better protect Marylanders during supply chain disruptions. What the bill doesn't do, the bill does not necessitate any increased cost to consumers. It is possible a supplier may choose to hold additional stock at a greater expense, but a competitor may choose to do otherwise. The bill doesn't publicly disclose any competitive information from these entities. In fact, it precludes MEA from disclosing that competitive information and requires us to hold it closely. Just a brief history of kind of the genesis of this bill. We're essentially reinstating a prior state fuel security program known as the State Standby Petroleum Fuel Set Aside Program. I'll conclude there and turn it over to Chris Rice, MEA's Chief of Staff.
Thank you, Landon. Chair, Vice Chair, members of the committee, my name is Chris Rice. I'm Chief of Staff at the Maryland Energy
Chris,
Administration.
could you pull the mic up a little closer? Thanks.
Is this better? Thank you. Chairman, Vice Chair, members of the committee, my name is Chris Rice, Chief of Staff at the Maryland Energy Administration. Today, I am going to speak with you, give you a little bit of a brief overview and cover some highlights of the operational aspects of Senate Bill 719. The state fuel security program requires the coordination among 5 stakeholders: MEA, prime suppliers, non-prime suppliers, wholesale purchasers and resellers, as well as consumers. And it involves 5 different fuels: gasoline, middle distillates, propane, residual fuel oil, as well as aviation fuel. The director of MEA determines the appropriate percentage levels for each state fuel security product.
prime suppliers must reserve. However, the bill does establish maximum levels of those 5 products that I just mentioned. MEA will need to promulgate regulations to further specify program guidelines and structure. However, the program does allow MEA to issue an assignment for fuel to entities that fall into one of 11 categories. During an energy emergency, an eligible entity may request an assignment by submitting an application to MEA. On approval, MEA issues an assignment to the applicant and copies the prime supplier's representative.
Hey, listen, because this is an request department bill and you don't have a senator that has unlimited time, I'm going to give you some latitude. So why don't you, Ms. Rice, finish your what you want to say, and Landon, if you want to. I know I cut you off, but again, since you don't have a Senate sponsor to explain the
I will
bill.
be very brief. Data collection. Senate Bill 719 also requires the collection of certain energy-related data necessary to administer and gauge the efficacy of the program. Collection of this information is limited to data necessary only to fulfill the requirements of the program, and MEA will be required to protect the proprietary, competitive, as well as sensitive information from unauthorized access. And some establishing the program will be a victory in blue sky planning, and it will help the state ensure it's well prepared for energy emergencies that disrupt the delivery of energy commodities. For these reasons, MEA asks our committee for a favorable report.
Okay, Mr. Farragut, since I cut you off, do you have any, you wanted to finish your?
Certainly, I was just going through a brief legislative history. So the original program was established in 1982. It was renewed several times, 2000, 2005, and then it sunsetted in 2010 on information belief. Part of the reason was that there just wasn't a need. As Chris brought up, this is a blue sky planning event, right? Like today is a perfect example of that blue sky day. But if we look back just a couple of years to the Colonial Pipeline incident, the invasion of Ukraine, and that disruption on supply chains, as well as a handful of natural disasters that have occurred in the last 15 or 20 years here in Maryland, any combination of those events could be disastrous. So that is why MEA feels strongly it is important to reinstate this program into state law and to give a tool in the toolbox for the state to deal with catastrophic events.
Okay, Senator Hester.
Mr. Chair, I was curious which other states currently have similar programs.
Senator Hester, thanks for all your work on resiliency efforts in the state. Currently, I believe that California and Vermont are the only 2 that have codified programs. The National Association of State Energy Offices also has they have model executive orders, so it is possible that other states would just rely upon that in the event that such an event arose at that time.
Any additional questions for the MEA panel? Okay, seeing none, we do have 2 witnesses signed up unfavorable. I don't see Mr. O'Halloran here, but I do see Ellen Valentino. And Ms. Valentino, you've got 2 minutes signed up unfavorable. And do you know if Mr. O'Halloran's here?
He's not. I will
Okay.
speak with one voice. Thank
Gotcha.
you. My name's Ellen Valentino. I'm here today on behalf of the Mid-Atlantic Petroleum Distributors Association. And although we think this is an important conversation to have, we do think that the bill is ill-advised on many levels. And I want to talk about the industry's concerns, and then I think larger policy deliberations that need to take place. Our industry concerns do center around data collection, data security, data control, a chain of command, a product, payment to us, and the calculations made in the legislation. We don't understand how they arrived at them. From a policy perspective, I think that's important to deliberate whether this kind of authority should stay with MEA or whether this should be done in collaboration with MEMA. So we've had a conversation with MEA, the people who just spoke, and we thought the conversation was an important one, right? But we absolutely think that this bill has not been well thought out. There are a number of stakeholders that I think voices need to be heard, including essential services, potentially other agencies that need to be heard. And certainly, I think a regional discussion is probably in order, for the state to set up what, by all accounts, is their own strategic reserve fund for emergency services. I do think there needs to be more dialogue and more consideration. Again, you have our industry's commitment to have open dialogue with this administration, both MEA, MEMA, and the governor, preparing for clearly what we have seen in the past, emergency times where it's important to get fuel to different parts in the state in a timely manner. So we request an unfavorable report. Thank you.
Okay. I see Senator Carrozza's light on. Senator Carrozza.
Thank you, Mr. Chair. And just to go back to the points about who has the authority and how those decisions are made. And as I understand it, you had mentioned a possible role with MEMA, ? And then from the standpoint of how much, how this decision is made. And I guess what I'm trying to figure out here is when it comes to like Homeland Security decisions, those type of emergencies, in the end, the governor is always held accountable. That's why it was, I believe that's why it's set up that you have a Homeland Security Director that's a direct report to the governor, as opposed to giving that authority to any one agency or department. And I guess I'm trying to understand on, are you raising both policy questions as well as where the authority should be established?
I think from a policy perspective, I think it's important for an administration to have an open line of communication or a plan in time of emergency, particularly when it comes to the distribution of food, water, fuel, those type of things. This bill takes the entire authority, in my view, and gives it to MEA. I do think that's a policy deliberation when you're dealing with the critical time when you are strategically reserving fuel for distribution and then deciding when it has to be released. So do I think that that is probably a role for other agencies? I do, but I'm not a state senator or a policy deliberator on this important matter. I would think my initial reaction was this belonged with MEMA. This belongs with the MEMA, not MEA. But that's my opinion. And that's not a deal breaker for us. Okay. I'm just saying that it's a major policy decision that should be determined. Additionally, I would not rule out having to have also a role of the Department of Commerce. They're the ones that are going to probably be communicating like they did during COVID. And I hate to use that example. We're talking about an emergency situation, identifying commerce and the need to make sure that there's fuel available for different reasons throughout the state. I'm just saying that this sole responsibility and authority with MEA, I think, is a major policy decision that needs more deliberation. We think it's a mistake, but it's possible that you choose to think that that's where this should lie. Thank you.
Okay, Senator Washington.
Thank you. And I am interested in this bill, and so you're not opposed to the program.
We're not opposed to having the discussion and the need for the state to have communication and a plan. We're not, the calculations in this bill, this program outlined in this bill, we do have pretty significant issues with, and we could walk through them one by one, but for the state to have a plan in place to communicate not just fuel distribution, water distribution, food distribution, baby formula distribution, we think that that's a conversation that should be had, and there be a strong line of communication with the suppliers of those entities. Yes.
So I just want to get some history. So
Sure.
the program existed in 2000, it stopped in 2000.
The history
Mhm.
that I know about this program
Mhm.
is the one that was articulated here by MEA.
Right.
I don't remember this program. There's got to be a reason why it's sunset 1982. You know, I can't talk about the history. I know that for whatever reason, this program sunsetted and it doesn't exist to the best of our knowledge, except in the two states that they articulated in, and I'm not even familiar with them. So I wish I had more history on that, but I do not.
And so what you're saying is that you do believe that the state has a responsibility, or that one of our responsibilities is to ensure that there's sufficient fuel, you know, for a range of reasons, or a range of uses, particularly some of the healthcare, emergency services, law enforcement, sort of transportation, that to ensure that we don't suffer, that we have reserves, that you support that idea. It's about how we do it. Or are you saying that it simply should be a conversation and a voluntary situation versus the state actually creating a system in which we have money in the bank as a state we have fuel in the bank when to address any emergency?
You know,
I'm trying to
I think,
clarify.
we're trying to clarify. This bill is stunning, and the uses for it go much greater, okay, than what you just outlined. It goes into giving our fuel to our competitors to operate. It goes into a number of things. Do we think that there ought to be a conversation in this state about emergency times and how to secure fuel, baby formula, water, food? Absolutely. Do we think that this ought to lie with MEA from the fuel perspective? You know what? I think that's part of a larger conversation. I absolutely do. So are we against entering a conversation with this administration over security in times of emergency? I think it has to be done. I think it's a necessity.
Great. All right.
Thank you.
Thank you.
Okay, any additional questions for the witness? Okay, seeing none, that concludes the bill hearing on Senate Bill 719. So I see Senator Hayes and Senator Klausmar. So we have a one witness for Senator Klausmar has one witness, and we're going to bring up Senator Klausmar on Senate Bill 473, and then we've got three Senator Hayes bills to close out our bill hearing. So Senator Klausmar, you've got one witness, Patrick Gubeo from the Maryland Military Coalition, who signed up favorable, and again, Senate Bill 473. And who do you have to your left?
I have Sam in case I can't do it.
Yes, okay, we know you're a bit challenged.
Do you
with your
mind?
voice today, so we're gonna, no, that's fine.
I'm gonna let
we
him
get
read
it.
it.
So, okay,
I'll
well,
try.
Sam or Senator Klausmar, you got the time you need to tell us what's in the
Okay,
bill.
thank you. Because this is a very special bill to me, so. Senate Bill 473, commission to establish a memorial to the global war on terror. Good afternoon, Chair Feldman and members of the Education, Energy, and Environmental Committee. I am proud to sponsor Senate Bill 473, which creates a commission to build a memorial that honors veterans of the global war on terror and their families. The global war on terror began as a result of the deadly September 11th attacks and ended 20 years later, becoming America's longest war. There are currently over 3.7 million veterans that have served since 9/11, and almost half of them report having service-connected disabilities. For these veterans, the war has never truly ended. Maryland in particular plays a substantial role in our nation's defense. Since 9/11, nearly every unit of the Maryland National Guard has served overseas in the global war on terror. The sacrifices of these individuals and their families have often been overlooked and it's time to begin honoring them. World War II ended in 1945, yet the Maryland General Assembly did not establish a commission to create the World War II Memorial until 1991, 52 years after the war ended. This memorial was dedicated in 2008. Many of you have seen them. It's right over the bridge by the Naval Academy. And many veterans of this war did not live to see this memorial. Over 20 years have passed since the beginning of the global war on terror. These veterans should not wait another 30 years to be honored. This bill gives us a chance to recognize these great Americans now. I thank the committee for their time, and I'm requesting a favorable report. And part of the reason I put this bill in is because a new delegate in my district, District 8, has served 2 terms in Afghanistan, and he is just a real proud American. And I'm just very proud of him. And so with that, I'm going to pass one.
Okay, before you do that, which delegates, we can give him some public acknowledgement here.
Should I say Nick, Nick Allen?
Okay.
He was in the Army. And I'm very proud of him.
Great. Okay. Thank you, Senator Klausmeier. Why don't we go to your one witness and then we'll take some questions if there are any. Mr. Gabello, on behalf of the Maryland Military Coalition, you've got 2 minutes to weigh in here.
Thank you, Mr. Chair. I'm Patrick Gabello, representing the American Legion and the State's Fleet Reserve Association. My testimony has been submitted, so I'll just point out a few highlights. Both organizations strongly endorsed Senate Bill 473. This measure would memorialize the 128 men and women who gave their lives during this terrible conflict, recognizing those who returned from Afghanistan, Iraq, and other combat zones. Some have been broken by this war. Creating a commission to develop a suitable memorial would honor those 1,537 Maryland veterans, some who gave a lot, others who gave their all. The American Legion, in conjunction with the Fleet Reserve Association, both internal veteran service organizations whose membership in our state exceeds 142,000, urge this committee to offer a favorable report on Senate Bill 473 to help bring closure to our veterans who served bravely in the defense of liberty. We thank Senator Klausmeier for her abiding respect for the military and its veterans. Thank you.
Okay, do we have any questions for either Senator Klausmeier or witness?
I would just like to add one other thing.
Sure.
Our previous Pat Young, he was a delegate, now he's a councilman, and he was very active in our Veterans Caucus, and I believe served, and he has some information in your packets.
Okay, great.
So, and he would have been here today, but he could not be.
Okay, well, rest up that voice. We need you at 100% for the
In case
move
we're
forward.
going
Okay,
to do karaoke or something.
Right. Okay, I don't
Thank
see
you.
any questions. That completes the bill hearing on Senate Bill 473. We're going to next turn to Senator Hayes for a troika of bills, and we're going to start with, I think, Senate Bill 332. That works for you, unless you have a choice. Do you have any preference on? Okay, well,
That sounds just about right. Mr.
okay,
Chair.
Drew, we've got one witness signed up, Drew Hawkins.
Yeah.
Can we bring Mr. Hawkins up if he's here? Or?
Drew had to depart because of
Okay.
the late in the.
Well, then
late
you're
in the day.
the whole game in town
I
here on this
admit.
bill. Okay, Senate Bill 332, Senator Hayes.
All right. So good afternoon, Senator Kramer, Vice Chair, if you were here, but good afternoon, members.
Did you call me Kramer or just, you know?
Did I say Kramer?
Yeah.
Oh, sorry.
Man, I just.
It was on my mind.
We spent way too much time together in the last quarter.
It's
that
my
last 4
secret.
years.
We just sat through 3 of Kramer's
That's
very
okay.
long bills.
That's okay.
Good
This
afternoon,
still-
Chairman.
This bill's still alive. It's good.
Chairman Feldman, good afternoon, and members of the E3 committee, I think you guys are calling it these days, Education and Energy and the Environment. Thank you guys so Thank you all for having me here this afternoon. For the record, I'm Senator Antonio Hayes, representing the 40th Legislative District of Baltimore City. The Reginald F. Lewis African American Museum in Baltimore is a national treasure to all of us here in the state of Maryland. When the board was first established, it was determined that they needed a large board of directors. They had 37 members, but since its creation, they have very rarely had all of the seats filled on their board. And having a board so large has rendered them not to be effective in many ways. And so Drew Hawkins, who would have been here earlier, served as the chair of their board, and has asked me to present this legislation to you all today to recommend a reduction in the board from 37 seats to 25 seats, continuously having the same representation from many of the institutions that are significant, but also allowing the discretion of 19 seats to be appointed by the governor with various expertise. And so you have the testimony before you. With that, I will urge a favorable report. There's one amendment to Senate Bill 332, and that is essentially giving both presiding officers an opportunity to appoint to the board. Although this institution has statewide significance, because it's located in Baltimore City, I presented this bill to the Baltimore City Senate delegation. It received unanimous support from the Baltimore City Senate delegation. And with that, Mr. Chairman, I recommend a favorable report with amendment to Senate Bill 332.
Okay, any questions for the sponsor? Senator Hayes? Yep, Senator Gallion.
Thank you, Mr. Chair. Thank you for this bill, Senator.
Yep.
I just looked, the fiscal note says the number 23, and then I believe the bill text says 25 members.
Right.
So how does that, can you explain that?
Yeah, so the amendments would incorporate those 25 members.
So 25 is what you want?
Yes, sir.
Okay, thanks.
Thank you so very much.
Okay, any additional questions? Okay, seeing none, that concludes bill hearing on Senate Bill 332. We're going to next move to Senate Bill 371. And should I call up the two witnesses who signed up?
Yes, I have Lisa Harris Jones. The other gentleman who signed up will not be here. He was just listed just in case Lisa Harris Jones wasn't available. But I do have Carl Hecker here only for technical questions if asked, but no testimony.
Fair enough. Well, why don't you lead off on Senate Bill 371 and take the time you need to explain.
Absolutely. Good evening, Chairman Feldman and members of the Senate Education, Energy and Environment Committee. So I had to read from the script that time, make sure I got it right, Mr. Chairman. For the record, I'm Senator Antonio Hayes from the 40th Legislative District in Baltimore City. Senate Bill 371 seeks state level clarification of a conforming interpretation of allowable uses in the underlying commercial district adjacent to a waterfront within an appropriate radius from a rail transit station. This clarifies mixed-use development, specifically including multifamily property, is an allowable use within the catchment areas within the legislation. And while the Baltimore City Council, Planning Commission, and Mayor Scott's administration will have an active role in reviewing and approving any plans for redevelopment along Baltimore's waterfront, this legislation will ensure the state's interest in promoting tourism, a clean harbor, a healthy Chesapeake Bay are protected and appropriately represented as major drivers of the state's economy. On a panel, I have with me Lisa Harris Jones and Caroline Hecker, representing MCB. Mr. Chairman, this is also a Baltimore City specific bill. It received a unanimous support of Baltimore City Senate delegation, and I urge a favorable report for Senate Bill 371.
Okay, why don't you pass it next to Lisa?
Yes, sure.
So you have 2 minutes.
Sure. Good afternoon, Mr. Chair, members of the committee. I am Lisa Harris Jones, and I represent MCB Real Estate. MCB will be the developer for the Harbor Place. And this bill, the senator did such a lovely job with going over the specifics of the bill. I really don't have anything to add except for the fact that if we would like a favorable report, because it will allow the developer to be able to do as much as possible
with the harbor when they look to develop plans and they get, feedback from Baltimore City residents, the city as well. And we are looking for a favorable report.
Okay, any questions for Senator Hayes or Ms. Jones? Seeing none, that concludes bill hearing on Senate Bill 371. Takes us to our final bill of the day. Senator Hayes, Senate Bill 445. And Senator, you don't have any designated sponsor panel, but there are 3 witnesses signed up favorable. I don't know, would you?
Absolutely. I would ask that Bree Jones, Claudia Wilson, I believe, Dan Ellis, please join me.
Okay,
as
those
a
are
part
the
of
3
witness
signed
panel.
up witnesses. So again, Bree Jones, Claudia Wilson Randall, Dan Ellis, why don't you come up and join Senator Hayes? And Senator Hayes, Senate Bill 445. Or one of our witnesses, I guess, not here today. Which one?
She's on the other
side.
Okay, well, if she shows up, we'll let her sit here.
Which one? Yeah. Can we substitute Claudia out, Mr. Chairman?
Sure. I mean,
Okay.
yeah, that's fine. Who do you want to bring up?
Nika?
Okay.
All right.
Okay, back to you, Senator Hayes. You take the time you need. Senate Bill 445.
Thank you, Mr. Chairman. Senator Antonio Hayes, for the record, representing the 40th Legislative District in Baltimore City. I'm pleased to present to you Senate Bill 445. Chairman Feldman, members of this committee, this is probably my greatest priority this legislative session. In 2021, you will hear in a minute from Bree Jones, who has been a leader in looking for opportunities to provide affordable housing here in our state. And it was mostly her brainchild that came up with the legislation before you. Since 2021, and working with the Maryland Department of Housing and Community Development, we recognized that there was opportunity to make improvements on the bill that this committee passed to make it more attractive to others. I'm gonna go to the script because I don't want to miss any important points. But in 2021, Senate Bill 859 passed, which established the appraisal gap for historically redlined communities financial assistance program. The purpose of this program is to provide financial assistance to affordable housing developers working in low-income census tract in order to help close appraisal gaps that occur in historically redlined neighborhoods. It allows an individual or business entity that incurs eligible construction expenses related to the construction of sustainable rehabilitation and residential property in low-income areas to apply for financial assistance. Senate Bill 445 seeks to strengthen the original bill by redefining what affordable means in reference to how much a family pays in housing costs to the IRS definition, so that it allows younger people with more capital and a limited income to be able to apply for this program. Right now, the appraisal gap program does not allow its financial assistance to be used for loans and requires applicants to wait until a fiscal year when a project is complete to receive funding. This bill also seeks to expand how financial assistance can be used and push the application timeline up so that program works better for smaller developers and individuals who may not have the capacity to pay out of pocket and wait for capital assistance. Again, the proposed amendments in this bill will allow the appraisal gap program to expand so that more people and developers can invest in communities. Another important part of this, especially as it relates to some of our rural communities outside of Baltimore, it allows for the expenses to be used on infrastructure. Typically in some of our rural communities throughout the state, infrastructure is a major barrier to providing affordable housing in the form of home ownership. This bill expands the definition to allow that all Marylanders are inclusive in this process. On the panel today, I have with me Bree Jones. Claudia is not here, but I have Nika as well as Dan Ellis from Neighborhood Housing Services. And I urge a favorable report for Senate Bill 445. If you look in your bill folders today, there is an extensive amount of testimony from many housing service organizations, as well as the Maryland Department of Housing and Community Development, who have been instrumental in making the updates to this legislation this year. So with that, I'll pause and I urge a favorable report for Senate Bill 445.
Okay, thank you, Senator. Do you want to start with Bree Jones?
Sure.
Since
Thank you.
Okay.
Good afternoon, Councilman Feldman, and to the committee. My name is Bree Jones, and I'm the founder and CEO of an organization called Parity. And I also just want to say thank you to Senator Hayes for his leadership. So Parity Homes, what we do is a little bit unique. We essentially pre-sell homeownership opportunities in some of West Baltimore's most disinvested communities, effectively dismantling the myth that there's no interest or demand for housing in these communities. In fact, we're pre-sold across several blocks of properties. But for example, on the 500 block of North Carrollton, we have been able to acquire all of the abandoned buildings on that block, but we have a gap of about $40,000 to $60,000 per property between the costs of construction to make those dilapidated buildings livable and the affordable sales price to our home buyers. For small developers and nonprofit developers like Parity, we have to be really creative around how we fill that gap. And whether it's private philanthropy or historic tax credits, we have a lot of tools in the toolkit, but this is one additional tool that makes development more attainable for small developers and for the homeowners and homebuyers that we serve. What's really unique about this bill, when it was passed in 2021, we received an outpouring of support across the country of other legislators that wanted to implement this in their municipalities. So in many ways, Maryland is leading the way for racial equity and really serving as a strong example for the country. And when this is fully funded, it has the opportunity to potentially create an additional 800 units of housing across the state. And that's just really exciting for Maryland. So I urge a favorable report of Senate Bill 445. Thank you.
Okay, who do you want next, Senator Hayes? Okay, tell us your name. Our substitute witness.
Sure. Good afternoon. My name is Nika Namdi. I'm the creator of Fight Blight Be More and the co-creator of the Stop Oppressive Seizures Fund. And our work centers on blight remediation in a way that does equitable community development in Baltimore, but particularly in Old West Baltimore. I live in Upton. Bree's work mostly centers in Harlem Park, so her work abuts my house and my community, and is really important to me. I just wanted to know this, the amendments to the bill allow for infrastructure and why that is very important. So on the 500 block of Carrollton, where Bree is doing her initial properties, the city has come through, a DOT has come through and done upgrades to the street and to the sidewalk, but they didn't repair the sidewalks. So the sidewalks are cut up and broken up. And this kind of funding will enable the developers like Bree to be able to include infrastructure supports, lighting, all of those types of things that make not just the houses grow in value, but make the community grow in value. So I'm here to urge a favorable report on Senate Bill 445.
Okay, Mr. Ellis, you can play cleanup.
Good afternoon, Mr. Chairman and members of the committee. Thank you for the opportunity to speak. I am Dan Ellis. I am the Executive Director of Neighborhood Housing Services of Baltimore. We are a nonprofit organization that believes that economic and social justice is a right for all people and communities. And we do that in a number of ways. One is helping people buy homes. So we've helped between 300 and 400 people a year for the last several years purchase homes. We also do community development, which we're doing primarily in West Baltimore, where we're developing this year about 30 homes. Of those 30 homes, about 20 of them have what we call as an appraisal gap. That means that it costs more to develop the home than you can sell it for. And what this ends up resulting in is for most people, you're not able to do the housing development, or it greatly limits your ability to do it because of funding availability. One example of this is a house that was recently done on the 3000 block of Walbrook Avenue at 3007 Walbrook. The cost to buy the house and renovate it was $277,000. The house appraised and could be sold for $233,000. That left a gap of about $44,000. This bill and the expanded definitions included in it, when funded, would allow that type of funding to be closed. Right now, there are places where we can go for that type of funding support. The problem is that they're limited. This particular house, it was closed through a federal program called New Market Tax Credit. But that's very limited and it limits how much we can do. So the more tools that we have available will allow more houses to be done, not just in Baltimore City, but around the state, to ensure that all our communities have affordable housing available, that the dilapidated homes can be repaired throughout the state. So we encourage a favorable report on Senate Bill 445. Thank you.
Okay, thank you. Any question for sponsor Senator Hayes or any of the panelists? Senator Hester.
Thank you very much. I was just looking at the fiscal note and it says there's no fiscal change because the program hasn't been funded. Does it need to be funded?
Yes, the bill has
Yes.
to be funded. It's a long story that I love to share. And so essentially when we had the bill passed in 2021, we thought we had a commitment from the administration at that time to have it funded. A couple of months after the legislative session adjourned, the administration funded it, but they rebranded it and called it by a different name. They named it Home Ownership Works, and they identified it as a pilot. And so the administration identified 2 neighborhoods that they funded at the tune of $10 million. And so we haven't been successful up until now to get it. We're lucky that in our testimony in 2021 before this committee, then a gentleman by the name of Wes Moore testified on behalf of that bill. And so we're hoping that this administration will be more open to working with us and recognizing the importance of this legislation.
Hey, Senator Watson.
One question. You had mentioned that it costs more to develop the house than to sell it. So I'm going to translate to say that if you purchase a property and you upgrade it and try to flip it, you're not recouping your cost.
Correct.
Okay. And so when you try to sell the house, is the value of the house being given based on like sales in that area?
Yeah, it's an appraised value. So it's an appraisal is done on the property and that generally.
So that appraisal is reflective of that community.
Correct.
So just bear with me. I got to ask the question. So we're not going in and putting in high-end appliances and thinking we're going to recoup the cost.
Correct.
If the houses in the surrounding communities don't have those luxuries, right?
Correct. Yeah, and the cost of developing houses, just to expand a little bit, is really primarily on the structure of the house. It costs anywhere from $150 to $165 a square foot at this point to renovate a house. It used to be 110, 100 to 110. And the difference between 150 and 165 would be some of those finishes that you're talking about, that type of thing. And the department can put regulations on the level that is acceptable. But what where the real cost is when the roof is in the basement and you've got to build all the floors and all the stairs. The structural cost is in addition to those costs of redoing the house. So some of the houses in the stock that we're dealing with have significant structural costs before you even begin working on the walls and the staircases and those.
So in some cases, you're building a house from the ground up.
That's right. Well, yeah, within the existing footprint and frame.
Right. And so we're dealing with a similar situation in Prince George's County, and we're trying to address, what we call appraisal bias. And some would contend that a house built by Ryan Homes in one part of the state and that identical house built in another part of the state should be identical in price. But there is this discounting that is a result of the perception of schools, the perception of crime, and those other impacts. And I'm just curious because this is an issue in Prince George's County we're actively trying to impact. And we have Delegate Marvin Holmes on the other side of the street trying to work on this. Do you have any insights so far related to that nuance, the community versus just the pure cost of materials?
Yeah, so obviously appraisal bias is an issue that we experience in Baltimore as well, as you've seen in Prince George's County. And there's lots of research and some anecdotal studies that have been done on it. And there's a lot of federal work that's going on around the appraisal work in addition to the state work that's going on. And so as developers and as community developers, We are very aware and supportive of the efforts to change the appraisal gap issues because it's affecting our community. But it doesn't necessarily solve the problem of how do we fix the houses now until we solve the problem. So this would, I would say, would be companion pieces that we can work on together. Let's solve the appraisal bias in our communities because they're very real. And quite frankly, a house should be what a house is worth, depending on what it's valued at. But we also need to close the appraisal gap that exists within the property, which we have in Baltimore, and I know you have in Prince George's as well, the same. And it's not just an urban or African-American community issue. It's around the state. You go down to Somerset County or other parts of some of the rural Maryland, there are significant issues with the cost of doing the house versus the benefits you get in. So our hope is that the bill can be structured in a way that helps the entire state, not just one particular jurisdiction.
Is when you're considering this, because I used to live in North Baltimore. So I'm envisioning, a whole block that really, when you talk blight, it needs to all be bulldozed and built up from the ground up. And so if you're going to do that and put a corresponding price on it, it seems that price has to also be a function of the amenities nearby. And so it's not just tear down a house, build a house up and expect you're going to get this money. You got to have places to shop, places to eat, those kinds of things that want folks to come there and pay slightly a higher premium to have access to that newly constructed property. So I wanted to see if you were also, in addition to the physical houses, looking at the corresponding amenities in the community.
Yeah, absolutely. And so our organization, we also do some economic development work. So in all of our houses are in a 5x7 block area of West Baltimore by Coppin State. I presume you're familiar if you lived in Baltimore, right next to Coppin State University. We're also building a food hall in West Baltimore on North Avenue next to Coppin State at 2636 North Avenue. It's creating 28 jobs, 6 vendors coming in, but it's something that's exciting the community because up until now, West Baltimore, which is probably about 100,000 people, has one sit-down restaurant. And that's in North Baltimore where I live, up by Senator Washington, my senator. We have a lot of places that we can walk to and eat. And I take that for granted, but I've learned from my friends in West Baltimore, they don't have that same privilege. So we are working on doing that, creating those opportunities. We need more of that in our communities. We are looking at addressing it, but we invite any support from the state available to help do that is possible.
North and Longwood. So
okay,
I think
that's right. That's West Baltimore.
Okay. Thank you very much.
Yeah, you're right around the corner.
All right.
And another thing, Senator, to your point around the appraisal bias, I've been Delegate Holmes has worked extensively on this issue. I think at least 2 bills that will come to this committee later this session to deal with that. One of the biggest problems and barriers to dealing with the appraisal bias is the pipeline to be an appraiser here in the state. The Appraiser Foundation just 2 years ago presented an alternative to some of the barriers to becoming an appraiser, which lacks diversity greatly. And so you all will hear that bill in short order. So.
Well, I'm just looking at the bill. I'm just trying to get this because we're talking about financial assistance for a proposed project under the bill as opposed to a completed project. But when I look at like the definition in the bill of construction expenses, it talks about expenses that have been expended. So I'm trying to jive here, the bill draft here between you're asking for financial assistance for a project that's proposed, but then definitionally, we're talking about expenses that have been expended. That is, so I just putting it out there in terms of making sure everything's jive and drafting what it's an intent issue. I don't know.
No, absolutely. That change was very intentional. It was one of the suggestions that Maryland Department of Housing and Community Development recommended. Oftentimes when you're, embarking upon one of these development projects, there's often expenses that a developer incurs even before they start with that development. A lot of planning, design is often referred to as like the pre-development stage, and so there's often costs that they incur even before. One of the flaws that the department recognized, especially in dealing with smaller developers, oftentimes they don't have the disposable capital available to take on these projects. And so the department has recognized that they need the flexibility depending on the project to be able to provide some capital upfront even before the project began. And so the original bill did speak to just that, just only reimbursing. The department recognized in their experience in working with the diversity of developers that they need the flexibility to front load some of the resources, similar to what is provided when it relates to rental properties as well. And you know, and many of the state and federal programs that we refer to, including but not limited to the light income tax credits.
We may have to reach out to DHCD because, you know, I don't think you don't have any amendments. I'm just want to make sure that what you just said, you know, in terms of what's being reimbursed is consistent with the way the bill's written, and there might be a little disconnect. So I think we can clarify that, but might need some amendment language on that front. Any other questions for any of the panelists? Okay, seeing none, that concludes bill hearing on Senate Bill 445. That concludes the bill hearings for today. We're going to take a short break of 10-minute break, and then we've got about 3 bills on the list, and we'll hopefully discuss them. And so be back here in about 10.